Ladies and gentlemen, we are starting in no time. We once again request all of you to please settle down and keep your phones on silent mode. Thank you. Ladies and gentlemen, our special guests have joined us. Let's welcome them with a thunderous round of applause. Guest of honor, Shri Suresh Chandra ji. Special guest and keynote speaker, Dr. Rajiv Mani. Can we have a louder round of applause? Mr. Basudev Mukherjee, Mr. Hemant Sahai, Mr. Rajinder Kumar, Mr. Santosh Parashar. A very warm and hearty welcome to you. Thank you very much for joining us and gracing this event with your benign presence. Ladies and gentlemen, esteemed guests, legal luminaries, a very warm and hearty welcome to the ASSOCHAM Bharat Legal Conclave and the National Legal Excellence Awards 2023. Can we all start with a round of applause? Thank you very much. I'm your host Prerna and I am delighted and privileged to play host to such an accomplished audience. Ladies and gentlemen, Bharat Legal Conclave encompasses various sessions, each dedicated at exploring different facets of the legal landscape. Today, we have assembled a distinguished array of speakers, panelists, guests, who will be sharing their insights and expertise with us. And now, we'll take this opportunity to thank our event partner, AU Corporate Advisory and Legal Services, our evaluation partner, Kumar Law Associates, session partners, EY, AZBN Partners, Integrate Law Offices, our legal partner, Arnes Law, and our media partners, LawStrat and SCC Online. And now, ladies and gentlemen, I'll once again introduce our guest. We are honored to have with us our guest of honor, Shri Suresh Chandra ji, Information Commissioner, Central Information Commission, Government of India, and former Law Secretary, Government of India. Special guest and keynote speaker, Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, and Department of Legal Affairs, Government of India. Mr. Basudev Mukherjee, Assistant Secretary General, ASSOCHAM. Mr. Hemant Sahai, Immediate Past Chairman, ASSOCHAM, National Council for Legal Affairs and Regulatory Reforms, and Founding Partner, HSA Advocates. Mr. Rajinder Kumar, Co-Chairman, ASSOCHAM, National Council on Legal Affairs and Regulatory Reforms, and Managing Partner, Kumar Law Associates. Mr. Santosh Parashar, Director, ASSOCHAM. And now let us symbolize the illumination of knowledge and wisdom with the lamp lighting ceremony. I request all the esteemed dignitaries present on the first row to kindly light the ceremonial lamp.
Shubham kurutvam kalyanam arogyam धनसम्पदः शुभं कुरुत्वं कल्याणं आरोग्यं धनसम्पदः
A round of applause as we light the ceremonial lamp.
ज्योतिर्नमोऽस्तु ते दीपज्योतिर्नमोऽस्तु ते दीपज्योतिर्परब्रह्म दीपज्योतिर्जनार्दनः दीपज्योतिर्परब्रह्म दीपज्योतिर्जनार्दनः दीपो हरतु मे पापम् सन्ध्यादीपनमोऽस्तु ते ओ दीपब्रह्मरूपस्त्वं ज्योतिषां प्रभुरव्ययः ओ दीपब्रह्मरूपस्त्वं ज्योतिषां प्रभुरव्ययः आरोग्यं देहि पुत्रांश्च मतिं स्वच्छां हि मे सदा रवेरस्तं समारभ्य यावत् सूर्योदयो भवेत् रवेरस्तं समारभ्य यावत् सूर्योदयो भवेत्
Thank you very much. And may I now request the esteemed dignitaries to please be seated on the dais. I request the esteemed dignitaries to please be seated on the dais as now we'll start the conclave. Can we once again welcome the esteemed dignitaries present on the stage, gracing the stage with their benign presence? Thank you very much. You may please be seated. May I now request Mr. Basudev Mukherjee, Assistant Secretary General, ASSOCHAM, and Mr. Hemant Sahai, Immediate Past Chairman, ASSOCHAM, to kindly welcome our guest of honor, Shri Suresh Chandraji, by presenting a welcome plant. Shri Suresh Chandraji, Information Commissioner of India and former Law Secretary, Government of India. A thunderous round of applause, ladies and gentlemen, for our guest of honor, Shri Suresh Chandra. Thank you very much. May I now request Mr. Rajendra Kumar, Co-Chairman, ASSOCHAM, National Council on Legal Affairs and Regulatory Reforms, and Managing Partner, Kumar Law Associates, and Mr. Santosh Parashar, Director, Legal Affairs and Regulatory Reforms, ASSOCHAM, to please welcome our special guest and keynote speaker, Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Department of Legal Affairs, Government of India. A very warm welcome to you, sir. And with due respect, I request Mr. Basudev Mukherjee, Assistant Secretary General, ASSOCHAM, to kindly render the welcome address. Can we please welcome him on the dais?
Mr. Suresh Chandra, Information Commissioner, Central Information Commission, Government of India, and former Law Secretary, Government of India. Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Department of Legal Affairs, Government of India. Mr. Hemant Sahai, Immediate Past Chairman, ASSOCHAM National Council for Legal Affairs and Regulatory Reforms, and Founding Partner, HSA Associates. Mr. Rajendra Kumar, Co-Chairman, ASSOCHAM National Council on Legal Affairs and Regulatory Reforms, and Managing Partner, Kumar Law Associates. Ladies and gentlemen, legal luminaries, guests, and fellow participants, a very good morning and a warm welcome to all of you at ASSOCHAM's Bharat Legal Conclave and National Legal Excellence Awards 2023. The Bharat Legal Conclave has brought together the best minds from the legal fraternity onto one platform. ASSOCHAM's aim is to foster an environment where knowledge, experience, and innovation related to law converge to address some of the most pressing corporate legal issues of the time. Our focus is on topics that resonate deeply with the evolving legal landscape and which have effects on the businesses, economy, and society at large. By bringing the best legal minds together, We aim to harness the collective intelligence of our community to brainstorm solutions and strategies that can help us address these burning legal issues effectively. I encourage all participants to actively engage in meaningful dialogue, share their insights and experiences, and contribute to the collective wisdom of all of us. In addition, this conclave underscores the values of integrity, honesty, and excellence in the legal profession. As we come together to honor and recognize the exemplary achievements of legal luminaries, we do so with the utmost commitment to transparency and fairness in our evaluation process. Once again, I extend my warm welcome to all of you. May this felicitation ceremony and conclave serve as a celebration of the highest legal standards and a platform for dialogue and collaboration and source of inspiration for all of us. Thank you for all your kind participation this morning and to make the day a remarkable occasion dedicated to recognizing excellence, integrity, and the power of collective wisdom in the legal profession. Thank you.
Thank you very much, sir. May I now request Mr. Hemant Sahai to kindly deliver the opening address. Can we please welcome him?
Thank you. Thanks very much. Good morning, everyone. It is my honor and privilege to welcome the distinguished guests, Shri Suresh Chandra ji, Dr. Mani ji. The Bharat Legal Conclave, I think, promises to be unique in many ways, and I think we're going to see that as the sessions unfold. Also, of course, the culmination of the session with the distribution of the awards. The jury has spent significant time, effort, and thought process in terms of going through various very eminent recommendations, and actually shortlisting those awards was a fairly significant exercise. Prior to that, the sessions that we have planned promise to be invigorating because they affect not only us as professionals, but also in our individual personal lives. Some of the things that we will talk about and discuss are the evolution of the laws as they've taken place in the recent past. Issues like data protection affect each one of us, not just, like I said, as professionals, but us in our individual lives. In addition, there have been significant changes, improvements, amendments in corporate laws, and a lot of us practitioners are aware of that and are going to be practicing that, advising clients. And in that context, some of the changes like the new labor codes, the SEBI notifications, I think this is all very topical. So the sessions that are planned today, later, are topical. They will stimulate discussion because in the panel we have some eminent practitioners, both very experienced general counsels, private sector participants, of course, professionals from the legal profession. Thank you very much, and once again, welcome. May I request at this juncture to invite Shri Suresh Chandra ji? Is that the sequence, or would you invite him? Right. Thank you. Thanks very much.
Thank you very much, sir. May I now request the distinguished dignitaries on the dais to kindly release the ASSOCHAM's Bulletin, Volume 3 of 2023, which is a quarterly e-bulletin published by the Department of Corporate, Legal and Regulatory Affairs at ASSOCHAM. Ladies and gentlemen, with this we release the ASSOCHAM's Bulletin, Volume 3 of 2023. A round of applause. Kindly keep the applause going. Thank you very much. And now, with all means of warm and friendly welcome, I have the pleasure to invite on the dais our special guest and keynote speaker, Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Government of India, to address the August gathering. Can we all please welcome him on the dais?
Namaste to all of you. Respected Sri Suresh Chandraji, Information Commissioner, Central Information Commission, and former Union Law Secretary, Department of Legal Affairs, Ministry of Law and Justice, and the guest of honor for today's function, Sri Hemant Sahayji, immediate past chairman, SHM National Council for Legal Affairs and Regulatory Reforms, and founding partner HSA Advocates, Sri Rajendra Kumarji, co-chairperson, SHM National Council on Legal Affairs and Regulatory Reforms, and managing partner, Kumar Law Associates, Sri Basudev Mukherjee ji, Assistant Secretary General, SHM, Sri Santosh Parasharji, Director Legal, SHM, all the distinguished guests in the gathering, ladies and gentlemen. It gives me immense pleasure to be present here today at this Bharat Legal Conclave 2023. And I wish to extend my heartfelt appreciation and thanks to SHM for affording me this opportunity to address this august audience and be a part of this remarkable event. Today, at this Bharat Legal Conclave, I applaud the efforts of SHM for choosing a very pertinent and forward-looking theme for discussion during the day on different issues which bother us both as legal persons and as members of the society. The organization of the conclave has greater significance when we are celebrating the Azadi Ka Amrit Mahotsav, and during this period, the country has taken new resolutions and, chalked out a new program to achieve the aspirations and dreams of the people, and see that the goals which the country envisages for itself as a developed country by 2047 are achieved. Chambers of Commerce play a noteworthy role in articulating the needs and interests of their members. They are also key stakeholders in the development of Indian industry, businesses, and economy. Aligned with this vision of New India, SHM works as a conduit between the industry and the government. Now, the pertinent thing is regarding the Bharat Legal Conclave is regarding the reforms and the law processes and the judicial processes, what needs to be done so that we as a nation can proudly proclaim ourselves as a developed nation maybe much before 2047. We are now the 5th largest economy, and by 2047 we aspire to be maybe a 35 or 40 trillion economy. And for this, I think the whole ecosystem, including wherein the legal system is the most important part, needs to be refurbished and reinvented so as to meet the needs of the present time and the challenges of the future. And as we all know, that legal reforms is a continuous process of examining existing laws and advocating and implementing changes in the legal system, usually with an aim to embrace the enhance the efficiency of the justice delivery system. And as you know, access to justice is one of the most important aspects of our constitutional goals. And with regard to that, the government and the parliament has from time to time, made many laws. And the history goes back even to the prior to our independence, when the first law commission was established under the Charter Act of 1833 in the year 1834 under the chairpersonship of Lord Macaulay, which recommended the codification of the penal codes, the CRPC, and few other matters. Thereafter, the third, fourth, and the second, third, fourth law commissions were also constituted in the years 1853, 1861, and 1879. And respectively, during these periods, over a span of almost 50 years, they drafted a lot of legislations to suit their own interests and to govern India as colonial masters. Now, after independence, the founding fathers of our constitution and the first parliament, they realized the need for, having a local element in our laws and the need to reform the laws as per the Indian needs and requirements. And there was a clamor for re-establishing the Law Commission once again, and exceeding to that, the government in the year 1955, they had constituted the first Law Commission under the chairmanship of Mr. M.C. Setalwad, the then Attorney General for India, who was its first chairman. And since then, we have many law commissions in place, and the present law commission, which is the 22nd law commission, is now in place, and its tenure is till the 31st August of next year, 2024. Now, so these law commissions have been given a definite terms of reference and a mandate to deal with law reforms, and of course, a mandate also to, examine the need for the relevance and the need of the existing laws, and to remove also the archaic and the obsolete laws which are a burden on our statute book. And in this regard, they have submitted many reports from time to time. Based on those reports, the government has brought bills in the parliament to remove such obsolete and archaic laws. And during the last 9 years of the government, their endeavor has been actually to improve the access to justice platform, whether by the use of technology, by the reforms in the legal processes, and by the reforms in the alternative dispute resolution mechanisms. So the combined effort, in fact, has resulted in India gaining jumping lot of places in the ease of doing business index. And from 142nd rank in the year 2014, we are presently to rank 63 in the latest 2020 doing business index, which is in fact a great jump, and we maybe, of course, the rankings now have not resumed for some few years, but maybe whenever they are resumed, we are sure that we will be within the top 50 countries of the world. So how is it possible? So it is possible because there are several parameters, and the government has to lay down a path as to how we can, help businesses by reducing the compliance burdens, installing a confidence in them, in the investors, because when you aspire to be a 5 trillion economy in the short, maybe in the very short run, and further maybe the third largest economy, then you have to, in the long run, then you have to, relax and reform your all processes. Compliance burdens are one of the most important hindrances which the government has felt have not actually encouraged industry to their full potential. And in this regard, of course, I think a lot of compliance burdens have been removed, almost nearly 40,000 compliance burden as per the DPIIT. And the Jan Vishwas bill, which has recently been passed by the parliament, also has decriminalized many laws in many sectors. So, and of course, another bill is pending in the parliament, which would further, remove almost 60 laws from the statute book, because they are no longer serving the purpose for which they had been enacted. So this is a continuous process of reform, and rethinking and taking all the stakeholders together on this path of reform, so that actually it is for the benefit of the citizens of the country. Industries and centers of commerce are a very important role in the envisaging the economic goals which the country has envisaged for its people, and in achieving those goals, and the happiness of the people is something which matters most. So if the industry is governed, in a very robust and a very transparent manner, the employees and the people in general will be benefited by the good governance in the industry. And taking a cue, I think the government itself on its part has encouraged transparency in so many areas. In fact, our information commissioner is the guest of honor today, and he is in fact the best speakers who can say on the role of transparency in governance. Besides, I think the emphasis is also on the all-inclusive approach of the government to bring everyone on its side and empower them. I think the recent enactment of the Constitution 128th Amendment Bill, which is now 106th Constitution Amendment regarding reservation for women in the Lok Sabha, the Parliament and the state assemblies and the panchayats and municipalities. I think that is something which is a path-breaking step which we had been doing, thinking for a long time, but perhaps the time was not ripe, and now we have been able to achieve that. So I think the all-inclusive inclusive effort to include everyone in the society on the path of progress is something which the government is very seriously thinking and is acting upon also. Now to come back to the, easing the processes, judicial processes and the ecosystem which governs the whole dispute resolution mechanism in the country. Of course, I am also concerned with this because the Department of Legal Affairs where I work is one of the, has the prime responsibility of managing the litigation of the Government of India, of Union of India. Now almost as on date, we can see from the data available in the public domain, there are almost 5 crore cases which are pending before the various courts, including the Supreme Court and the tribunals. Now to ease that situation is something which we need to act very fast and quickly, and with that regard, I think the aim of the government to promote alternative dispute resolution mechanisms by way of reforms in the Arbitration Act of 2000 by amendments in 2015, 2019, 2021, then the recent enactment of the Mediation Act 2023, which we are very hopeful that would actually lay a new path of win-win situation for the stakeholders and actually maybe overtake arbitration as the most viable and the most appropriate form of dispute resolution amongst the parties, including businesses. And on this occasion, I think the representatives of the business and the lawyers who are present here, I think they should now emphasize with their own authorities that the contracts need to be reframed. And I think the mediation should be the first step for dispute resolution, failing which only the arbitration may be invoked. Secondly, the reforms in the quick resolution of commercial disputes has been one of the most major achievements of the government in the past years. With the enactment of the Commercial Courts Act in 2015, the time which is being taken for resolution of a commercial dispute has actually lessened greatly, and maybe earlier it was 1445 days as per the Doing Business Index report of the World Bank, but now it is, I think, nearly half of that duration. So this is, I think, and maybe we are contemplating, the government is seized of the matter, it is contemplating further reforms in the Commercial Courts Act so that the time dispute can be further reduced. And the introduction of the pre-institution mediation system, which in fact was initiated during the time when the guest of honor, Shri Suresh Chandra ji, was the law secretary. He was in fact the creator of all these ideas, and we acted upon his directions, and that has really benefited the commercial disputes resolution in a very quick pace of time, and benefited all the stakeholders who are litigating about those issues. Now, with regard to the legal reforms, as I said, it is a continuous process. The present, recently, as you are all aware, the 3 old pre-constitution laws which govern our criminal administration system, that is the IPC, the CRPC and the Indian Evidence Act, they are sought to be replaced with new laws, and the bill in this regard has already been introduced in the parliament, and the parliamentary committee is in fact examining those bills, and they will shortly come out with their recommendations. And in fact, the access to justice and the preventive, theory of, criminal jurisprudence, I think that would be strengthened once we actually have the real offenses being made punishable, and those which are trivial now being, removed from the statute book or made compoundable. So with this regard, I think the emphasis also is required to be given on the legal education, because ultimately it is the legal professional who gathers and the knowledge, the skill during his days as a student of a law school or a law college, and that process also is equally important for the government. The government and in association with the Bar Council of India has been very proactively working on the strengthening of legal education sector in the country. The Prime Minister, in fact, during in the last year when he had addressed the Chief Ministers and Chief Justices conference, he highlighted the use of technology in legal education and educating legal law students in various facets of technology, whether it is artificial intelligence, blockchain, and other means of use of ICT tools. The Bar Council was also very proactive in accepting the suggestions of the Honorable Prime Minister, and and they have in fact incorporated these subjects in their curriculum and circulated it to all the law colleges and universities. So in fact, it has to work in sync. The first, we have able law teachers, then we have able law students, and then they can actually turn out to be very good professionals. Because what we feel now is that India has actually dominated the world earlier in the field of medicine, and as intellectuals, Indian professors, you will find them in most of the universities and colleges, whether it is including, of course, the medical fields, and also in other leading universities of the world. Then there, of course, the IT revolution fueled the growth of Indian IT manpower, and they are occupying the leading positions all through the world. And now I think that the right time is now that we can actually have the legal professionals ruling over the various legal concepts all over the world, because it is the time that when we have the best law colleges, we have the best law students, and the best reforms in place which would facilitate the entry of foreign lawyers into the country, and making it on reciprocal basis accessible to the Indian students to practice law in foreign jurisdictions. In this regard, as you all know, the Bar Council of India has also come out with the entry of foreign lawyers regulations on 10th of March this year. So as we see that the comprehensive phenomenon which is in sync with the initiatives taken by the government at the policy level, the initiatives which the government has taken at the legislative level to reform the law. And as I mentioned, the 22nd Law Commission is also in place, and they have already given 3 reports, one on the sedition law, another on adverse position, and few more, in fact, are on the pipeline, and some of them are very important. I think, need to work in the approach, as the Honorable Prime Minister says, the whole of the government approach, or what we may now say as the whole of the nation approach to all these critical issues which affect us, which need to be dealt in partnership with the government, with all the stakeholders, including the industry and commerce, to see that the vision of a developed India by 2047 is fully achieved. In fact, I'm so thankful to the SHM and all the organizers of this conference that they have taken the initiative to hold this very, to this Bharat Legal Conclave on this very pertinent topic, and giving me an opportunity to associate with this legal conclave. I extend my best wishes to all of you. I'm sure the conclave will become successful to come out as an ideal platform for bringing together the best legal minds to engage in thought-provoking discussion, share experiences, and collectively work towards strengthening the legal framework in the country. Thank you, and Jai Hind.
Thank you very much, sir, for your insightful address. All your suggestions and advices have been noted. Thank you so much. Ladies and gentlemen, it is indeed an honor to invite on the dais our guest of honor, Shri Suresh Chandra ji, Information Commissioner, Central Information Commission, Government of India, and former Secretary, Ministry of Law and Justice, Government of India, to enlighten us with his words of wisdom. Can we please welcome him with a thunderous round of applause?
Namaskar. Respected dignitaries on the dais, Dr. Rajiv Mani, Additional Secretary, Ministry of Law and Justice, Mr. Hemant Sahai, immediate past Chairman, ASSOCHAM, National Council for Legal Affairs and Regulatory Reforms, and founding partners, HSA Advocates, Mr. Vasudev Mukherjee, Assistant Secretary General, ASSOCHAM, Mr. Rajendra Kumar, Co-Chairperson, ASSOCHAM, and Mr. Santosh Parasharji. All advocate fraternity, ladies and gentlemen. It is a proud privilege to be part of this august gathering, especially to discuss very important topics on the occasion of the Bharat Legal Conclave and National Legal Excellence Award 2023. The theme of Today's conclave include empowering innovation, empowering India, digital competition, merger and amalgamations unveiled, navigating growth and global opportunities, transforming disputes into economic opportunities, India's resolution path and compliance to commitments, embracing ESG and the rule of law. Though Dr. Mani has already covered all the aspects of the legal reforms, access to justice, legal education, and about the reservation and empowering women, empowering the advocates. So nothing is there for me, but I will like to add something in this and maybe contributing some thought provocation amongst the minds of the advocates. Before I delve deeper into the subject, I would like to congratulate all those awardees in anticipation of the SOCHM National Legal Excellence Awards 2023. These are some of the important topics which are frontiers, legal fields. And as Dr. Mani was telling about the history of legal reforms and the Law Commission reports and Law Commission studies, I was thinking of most of the time the Commission is involved in, further making amendments in the CPC, the personal laws, in this, all those criminal procedure code and all. And they don't do simply they are rephrasing the things, like they have very recently, labor code has come. If you see, nothing is there, they have amalgamated. But these are the topics which I am seeing, which requires creativity and lot of brainstorming. And we should, and I will request Dr. Mani to assign some of the important these topics which are nowadays required to be further discussed, and the legal framework in the light of the new technological developments which are required to be made, that legal framework. And here I am happy that the SOCHM has taken pain to evolve or to make out these topics. One of the topics is the competition, and that too in the digital fieldwork. The evolving of competition policy and concretizing the same into a binding competition law depends upon the ecosystem of laws and the environment in which the same operate. I shall be failing in my duties if I do not bring out the necessity of triggering the competition law in India. Before I dwell upon that, I would like to discuss that the Indian legal system operates under a scheme and has 4 components. First, the basic principles and values enshrined in the Constitution. Second, the rights and obligations contained in the various statutes. Third, the organizational structure in mechanism of operations of these laws. And last but not the least, legal personnel. And I am happy that the legal professionals are being awarded this time by the SOCHM. In India, there are over 15 lakh advocates, and they are equal partner in the in the justice delivery system. So this very important aspect of the Indian legal system has been given importance, and that gives me immense pleasure. Again, I would like to say, you see, Dr. Mani told that there are over 5 crore cases. In 2000, I remember the figure was 2.2 crores. And at that time, we initiated certain reforms, including the constitution of fast-track courts, development of the infrastructure, and also use of technology and also categorization of the cases which can be fast-tracked to the fast-track courts. At that time, I was I was also party to that, and there was a suggestion that to cope up with the pendency of the cases, we should appoint retired judges, which I discussed with the minister, and I told no. If you are appointing again the retired persons, it will be a retrograde proposal, and we should not accept it. And then he agreed, and we, as an encouragement and rewarding the young judges, fast-track courts were constituted 1735 or 1755 at that time, and they did a lot of good work. But anyhow, that was there, and I remember once the law minister was addressing, wherein the Chief Justice was also sharing the dais, and he told that there were some issues relating to, judiciary corruption and all that. Then the law minister had referred that there is lot of pendency, and the judiciary should itself, within the judiciary, they should manage, otherwise there will be outside interference. On that, Justice Anand told that, Mr. Law Minister, you first put your house in order, because more than 60% of the litigation comes from your government. So these are some of the things. We are taking lot of measures, we are talking high about the access of justice, and we say so many things, ease of doing of business and all. But if you see, net result is we are creating more and more confusion into this. I will not discuss in detail, but simply I will point out there is a need of introspection as to whether we are moving in the right direction as far as the access of justice is concerned, as far as the upholding the rule of law is concerned, as to whether the Ministry of Law, which is the main responsible ministry for upholding the rule of law, as to whether we are successful in doing that. Sir, again I will say we have 4 elements and 3 very basic principles under which our bureaucratic system works. I would like to point out those. Because unless you understand, you will not be able as to where and how the irregularities creep into the system and how these are being perpetuated. Government, which acts through a bureaucratic setup, follows the 3 principles. One is the backward-looking conception of legitimacy. Second, balance between the non-reviewable discretion and fixed rules. And the last, either deduction or correction thereof. There is a need of conferment of discretion, but the discretion will have to be exercised within the framework of the rules. And if within the system correction doesn't take place, then it is corrected from outside. That is the total sum of these. Having said that, now we may dwell upon what were the mischiefs which the competition law and policy aims to correct. The preamble of the Constitution emphasizes the unity of a nation, and it proceeds further to define the objectives of the Indian Republic. Articles 38 and 39 mandates inter alia that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may that the ownership and control of material resources of community are so distributed as best subserve the common good, and that the operation of the economic system does not result in concentration of wealth and means of production to the common detriment. In a case, while emphasizing the need for enactment of the competition law, issues legislation like avoidance of anti-competitive agreements and abuse of dominance, in the case of Competition Commission of India versus SAIL, the Supreme Court observed the decision of the government to liberalize its economy with the intention of removing controls persuaded the Indian Parliament to enact laws providing for checks and balances in the free economy. The laws are required to be enacted primarily for the objective of taking measures to avoid anti-competitive agreements and abuse of dominance, as well as regulate mergers and takeovers, which result in distortion of the market. The earlier Monopolies and Restrictive Trade Practices Act 1969 was not only found to be inadequate but also obsolete in certain respects, particularly in the light of international economic developments relating to competition law. Most countries in the world have enacted competition laws to protect their free market economies, an economic system in which the allocation of resources is determined solely by supply and demand. The rationale of free market economy is that the competitive offers of different suppliers allow the buyers to make the best purchase. The motivation of each participant in a free market economy is to maximize self-interest, but the result is favorable to society. As Adam Smith observed, there is an invisible hand at work to take care of this. Everybody gets his own share, but ultimately it is the society which gets benefited. Thus, the mandate to strive to promote the welfare of the people so that the ownership and control of material resources of community are so distributed as to subserve the common good, and that the operation of the system does not result in concentration of wealth to common detriment, which were in existence since independence. The MRTPC Act also aimed to achieve the aforementioned objectives, but it failed. Reason was that it provided that the companies with assets above 20 crores may further invest with the approval of the central government. The limit was again raised to 100 crores in 1985. This resulted in a situation where the dominant firms controlled the maximum market and had minimum assets, and hence were not attracting the provisions of MRTP Act. So these companies, having very limited capital, were sharing or involved in the unfair trade practices, bid rigging, and cartels, etc. That was the reason we came out with the Competition Commission of India. And in the last 3 decades, since 1991, the Indian economy has undergone a huge transformation with the gradual loosening of controls over private sector participation and foreign investment. With the liberalization policies, sectors such as automobiles, civil aviation, telecommunications, and broadcasting, there has been a tremendous expansion of choices available to the consumers. A competitive marketplace is utmost necessary to ensure that the producers and service providers constantly upgrade their offerings and make them more accessible to consumers. It is also important to encourage entrepreneurship by smaller players as well as new entrants so that they can compete with more established players in the marketplace. However, market forces cannot be allowed to operate in isolation since there is always a possibility of collusion between the market players and the consolidation of monopolistic practices. In the absence of effective government regulations, such collusion can lead to circumstances where a few players make extraordinary profits at the cost of smaller players as well as consumers. Hence, it is necessary to have an effective competition law regime which amounts to the interests of the various market players, the consumers, as well as the government. However, if you see the Act of 2002, has partially successful, but again I will say, seeing the examples of the monopolistic behavior of big tech companies like Google, Amazon, Apple, and Microsoft, etc., you will see that the level playing field for the new entrants or other developers is not as congenial as it should be. One of the reasons which I sometimes feel that when the Competition Commission of India was envisaged, at that time it was felt that the Competition Commission of India will be a body of experts which have the legally and judicially trained personnel, the experts who are expert in international trade, experts in the technology, intellectual property rights, etc. And it was not envisaged that they will act under any dictation or they will engage the legal professionals to give them input. If you remember, there is one Supreme Court judgment, State of UP versus Maharaja Dharmender Singh, which says that any quasi-judicial body which takes dictation or which acts under coercion or undue influence, it may not be taken that the decision which vests in that body is taken by that. And if it happens, then the very decision is without jurisdiction and ab initio void. If you go by these principles, what happens? Sometimes our so-called high label bodies, which have been given so much of power. I had spoken this last time also in 2017, and still it is true. And you may be aware of the directions coming from the Supreme Court, also calling the members. These are some of the basics, common things which cannot be understood by so-called our high-level experts sitting in these or manning these tribunals, how can they decide the rights and obligations involving complicated issues of facts and law? These are some of the important points which I would like to, impress upon and tell our decision makers who are even in the Ministry of Law to think of. As I know, Ministry of Law is not implementing the laws. Most of the laws are implemented by other administrative ministries. But Ministry of Law's input is just like a, common golden thread which is there present in all decision making, in the law making, and also in the judicial pronouncements. But somewhere it is missing. Maybe, I don't know. That was the reason, initially, if you see, there was only one tribunal prior to independence, which is called the mother of all tribunals, that is ITAT. ITAT was conceived by the Britishers and dealing with the financial matters, income tax matters, was placed under a Ministry of Law. Second, if you remember, they were the people who could understand, that what you call biasness or some kind of conflict of interest. In the Ministry of Railways, the safety is not with the Ministry of Railways. It is with the Ministry of Civil Aviation. Likewise, earlier, the Institute of Constitutional and Parliamentary Affairs, Constitutional and Parliamentary Affairs was under the Ministry of Law, now has been again taken away. What I'm saying you that there is a need to enforce the rule of law, and if you do not do that, then the irregularities grow and perpetuate, and the court cases increase as it is happening. We have, if you have semantics, you can have, very good articulation of words and can tell we have achieved the ease of doing business. We have done this. The improvement of, our placement in the ease of doing business by advocacy, by bringing so many other things which were not there. See, real work, if you do, will result in the form of effective operation of the governance. That's why there is a need of introspection by the young minds, by the advocates. There is a need, and these topics are very important they will provide you the food for thought. During my period, before I conclude, if you want to take India in 2047 as a developed nation and reach on the commanding heights, become either the second economy or the third economy, we have the capacity to become even the topmost economy. If you see the history, we were at the top earlier. So, India first, corruption free, and the governance, if you can make effective operation of the government, then you can achieve these objectives. During my period, we undertook certain steps I remember in 2000, we came out with the CPC Amendment Act, wherein the life cycle of a civil case was reduced from almost decades to 1 year. We made certain amendments in the Negotiable Instruments Act, changing the burden of proof, accepting the electronic form of summoning and all that. But unless there is somebody who can pursue those, these will not, yield results. The 30 days time, no court is now sticking. We have given 30 days time. Lastly, before I conclude, I will say that during my regime, we came out with the rationalization of tribunals, Alternative Dispute Resolution, Arbitration Act, Conciliation Act, Mediation Act. We came out with the commercial acts. We were also thinking of making environmental benches of the high courts instead of these green tribunals. I was thinking to bring out a law tech. I think Dr. Mani he was with me in London when we visited those. I have seen in South Korea also how the law tech offices and the legal people who are collecting data and thereafter bringing reforms. We started competence mapping. One more important LIMS, Legal Information Management and Briefing System, which is working in the government, very successful, that was also started. One, we wanted the international treaty revision and also integrated legal division. These were some of the unfledged my goals. I impress upon, I again ask our Additional Secretary in the Law Ministry to take these things forward. And I will also urge upon young lawyers, all those people, including SOCHM, that they should introspect as to what is going wrong in excess of justice, in bringing down the pendency. And more important, I used to say that there are three musketeers of any judgment. One is the simplicity, less costly, and fast. And most important, one more is there, fourth one, which I have added, is the enforceability. Unless your orders are enforceable, these are worth throwing in the dustbin. Lot of confusion is being created because of the, contradictory. I've finished. So with these words, I'm thankful to the SOCHM, all you people, you have invited me and given me an opportunity to share my thoughts. I hope some of our ideas will be taken by you and the SOCHM and the decision makers for the benefit of the society. Thank you. Jai Hind.
Thank you very much, sir, for your remarkable address. I'm sure all of us present here are highly benefited by the same. Thank you so much. Ladies and gentlemen, before we conclude the inaugural session, it is a tradition at ASSOCHAM to honor its distinguished guests with a token of gratitude, a token of respect. I request Mr. Basudev Mukherjee, Assistant Secretary General ASSOCHAM, to kindly present a token of gratitude to our special guest, Shri Rajiv Mani. Can we have the memento, please? Additional Secretary, Ministry of Law and Justice, Department of Legal Affairs, Government of India. A thunderous round of applause for our special guest, Dr. Rajiv Mani. Thank you very much, sir. We look forward to your esteemed presence in the coming times also with us. Kindly keep the applause going as we thank our distinguished guest on stage. I once again request Mr. Mukherjee to present a token of gratitude to our guest of honor, Shri Suresh Chandra ji. Information Commissioner of India and former Law Secretary, Government of India. A roaring round of applause for our guest of honor, Sri Suresh Chandra ji. Thank you very much, sir, for your benign presence, for your gracious presence. Look forward to your support in the times to come. I now request Mr. Rajinder Kumar to present an honor to Sri Suresh Chandra ji for his good self being a jury member of ASSOCHAM National Legal Excellence Awards. Once again, a round of applause for our guest of honor, Sri Suresh Chandra ji, for being a jury member of ASSOCHAM National Legal Excellence Awards. Thank you so much, sir. I now request Mr. Basudev Mukherjee to present a memento to Mr. Hemant Sahai, immediate past Chairman ASSOCHAM, National Council for Legal Affairs and Regulatory Reforms, and founding partner, HSA Advocates. Thank you so much, sir. I now request Mr. Sumit Malik to please join us on stage. He's Director, EBC Publications. Can we please welcome Mr. Malik on stage? I now request Mr. Rajinder Kumar to present a memento to Mr. Sumit Malik. Kindly keep the applause going, ladies and gentlemen. Thank you so much, Mr. Malik, for your support. Thank you very much, dignitaries. You may please be seated. Ladies and gentlemen, as we wrap up this insightful session, let's hear the concluding remarks and vote of thanks from Mr. Rajinder Kumar, Co-Chairman of ASSOCHAM, National Council on Legal Affairs and Regulatory Reforms, and Managing Partner of Kumar Law Associates. Let's welcome him.
Good morning, everyone. Respected dignitaries on the dais, distinguished professionals, ladies and gentlemen. India stands tall in the world today. We have grown at an exceptional growth rate of 7.5% yearly from 2014 to 19, and the quantum leap continues. In this backdrop, the legal conclave organized today, which is on the Legal Excellence Awards ceremony, comes at a propitious time. And I would like to summarize. Mr. Basudev Mukherjee mentioned about the aim to bring about solutions to the legal issues with value system. Mr. Sahai talked about and highlighted the critical significance of the topics in the session and the relevance. Dr. Mani very eloquently emphasized the need for enhancement of justice delivery system, reforms brought out in the last 9 years, the ease of doing business, and he also mentioned about the ranking in the ease of doing business, also mentioned about the pendency of the cases and the need for the ADR and the relevance of the Mediation Act, which has come. And I personally feel Mediation Act is a very, very helpful legislation which needs to be made use of by us, the professionals. So I urge the professionals to heavily encourage the use of this law. And Dr. Mani also mentioned about the reduced compliance burden, empowerment, knowledge, and the skills of the legal professionals in this critical arena. So I think these were some of the things. Then Shri Suresh Chandra ji gorgeously brought about various significant aspects. For example, the legal framework to be aligned in light of the technological developments, the need for encouragement to the legal professionals for which we all stand today here, the Constitution's mandate for delivery of justice to the common man, liberalization of economy and need for a competition law which averts the monopolistic practices of the few. He also mentioned about the effective implementation of laws and need for enforcing the rule of law. So these were some of the highlights. So I extend a very sincere thanks to Shri Suresh Chandra ji, Dr. Mani, Mr. Sahai, Mr. Basudev, and Mr. Deepak Parashar, and the entire team of ASSOCHAM consisting of Mr. Vikas, Jatin, Vishal, and Ritima, who have made untiring efforts for organizing this program. I also thank the jury for advising and supporting in the process of deciding the awards. So we now have very renowned panelists, and I am sure we are going to have very interesting and interactive sessions ahead with useful takeaways in our journey for growth. Wishing a grand success to the events ahead. Thank you.
With this, we come to an end of the inaugural session. Thank you very much, dignitaries, for joining us for the inaugural session. Once again, a round of applause, ladies and gentlemen. Thank you very much. And now, ladies and gentlemen, we'll prepare the stage for our first session. Our first session is on the theme Empowering Innovation, Empowering India, the Digital Competition Law. Ladies and gentlemen, please join me in welcoming session moderator, Dr. Paila Narayan Rao, Associate Professor and Head, School of Corporate Law and School of Competition Law and Market Regulation, IICA, Ministry of Corporate Affairs, Government of India. Can we all please together welcome our session moderator, Dr. Paila Narayan Rao. A very warm welcome to you, sir. I urge you to moderate the session and give me a minute as I introduce the key speakers. We have with us Mr. Sameer R. Gandhi, partner and co-founder, Axiom 5 Law Chambers. Can we have Mr. Sameer Gandhi on stage? A round of applause, ladies and gentlemen. A very warm welcome to you, sir. Ms. Deeksha Manchanda, partner, Chandok and Mahajan Advocates and Solicitors. A hearty welcome to you, ma'am. Mr. Toshit Shandilya, partner, AZB and Partners. A hearty welcome to Mr. Shandilya. And I now hand over the session to Honorable Session Moderator for further proceedings.
Yeah. So I welcome all the distinguished panel members here, and as you can see, the theme of this session is about empowering innovation, empowering India, the digital competition law. So let me give you a brief introduction about the idea of digital competition law. As you are aware that competition law enacted in the year 2002, by the time we didn't have too much of digitalization of businesses, business models, and slowly if you see the sector like health sector, education, transportation, even finances. So today we transact most of our financial transaction without even moving to any specific physical place, and everything is digitalized. So now the business models have moved from the traditional system to a digitalization, so you are able to continue all your works, everything using these digital methods. So as the business is growing in a digital manner, the business models also increased. Now, in an estimation, if you see the post-COVID situation also, the people who are not into this inclusion of this digitalization, now even across the official areas of India also started using the digitalization. But if you see the business into this particular area, there are very few players who are dominating. If you see from all the sectors from 2015. So competition law mainly addresses the issues that were in traditional model like anti-competitive agreements, abuse of dominance, combinations. They all were written long back in 2002. And subsequently, I think there was no much review also on it. But now the question is, these anti-competitive practices, abuse of dominance, and combinations in the area of this digital competition law is not exclusive part of the Competition Act. So now the question is, now the business is happening in this area of digital competition. So players are playing in this area, so there may be an element of anti-competitive practices. So whether our Competition Act is completely equipped to address those issues, though the judgments are getting passed, or we need a specific set of special regulation or any law that we need outside of the present competition law is the main core of this session. So for that, we have the distinguished panel to address the questions, which I have few questions to the panelist. And after that also, we'll take some questions from you as well, considering the time factor that as the session is already delayed, right? So now, the first question to the panelist regarding the ex-ante regulations. Whether we need ex-ante regulations to regulate this digital competition, the competition which is happening in this area of digitalization and digitalization business models. For that, we have a panel. The first question is about, sir, whether we need any ex-ante regulations or we need ex-post facto regulations. So we'll start with Madam Diksha ji to address this question, then we'll go to the other panels. Yes.
Thank you so much, and a very good morning, everyone. Thank you so much, Mr. Rao, actually, for setting out that context really well. I think the topic for discussion today has 4 very powerful words in it: empowering innovation, empowering India. And if you're looking at this discussion from the context of those 4 words, the policy goal becomes very clear. It's whether innovation is being encouraged by way of any new regulation. Do we need new regulation to encourage innovation? I don't want to actually venture into giving an answer here. I think this is something which requires a lot of in-depth empirical study, because this question of whether new regulation is required or not is always a very tricky one. You need to identify the policy goal, you need to see what is the gap in the existing regulation, and then you need to decide how best to address that gap. But just looking around us, we had a committee that examined this, Mr. Jayant Sinha's committee, and it actually came up with 10 anti-competitive practices that they thought plagued the digital sector. Interestingly, all of them are something that the competition regulator has been looking at and has been addressing, in my view, as a practitioner fairly effectively. That is one part of it. The second is we are seeing global interest in the digital markets, reasons which Mr. Rao has already explained. I think they are such pervasive markets and there's no value chain or there's no supply chain today which does not have a digital touch point. So of course there is a lot of regulatory interest. And what we are seeing outside perhaps provides us a good analytical framework to apply in India. But I think it needs to stop there. We perhaps need to look at very India-specific evidence to see whether the analytical frameworks which are being created or being used outside, and I think those largely remain universal, whether those get fulfilled in India as well. And on basis that, see whether there's a need. And finally, I think there's a need to figure out what are the costs of this regulation. Costs not just in terms of regulatory costs for the government, which of course is a very important element, but also for companies. What will be the impact of any of this on the companies who are subjected to the regulation and the companies who are linked to those companies which are subjected to the regulation, because digital markets are a very symbiotic, interlinked ecosystem. So you need to understand the impact at every level. So those perhaps are some, I would say it's a broad framework by which we can determine whether ex ante is needed or not. As I said, I don't want to venture into an answer prematurely. My sense personally though is that we are seeing a very flourishing economy, digital economy in India. Things that earlier could not have been done are now being done. You have SMEs who are able to maintain a direct contact and endpoint with the customers at very low cost. So we are seeing increasing competition, we are seeing low entry barriers, we are seeing increasing choice. And that somehow should be assessed to see whether we need a digital framework. Finally, I think on the point of cost, it's something that's not very often talked about, but I find some statistics very interesting. CMA did an impact assessment, the Competition and Markets Authority in UK, and they estimate that about 2,000 million pounds annually is what they estimate to be the costs of an ex-ante regulation. Similarly, EU did something, and a slightly different figure compared to the size of European Union, but they anticipate 60 million euros. And they anticipate additional full-time employees of about, I think, 80 employees to be added to the European Commission. So that, I think, is something that needs to be accounted for. We have a committee which is doing it currently, the Competition Law Review Committee, and I think I would leave for them to, I'm sure they're doing it already, and it would be great to see the report that comes out of the committee and how it addresses all of these issues.
And there's one criticism about when we are approaching to regulate the digital competition law is that we are looking at other jurisdiction because this law cannot be made only considering the Indian situation because the transactions are cross-border in nature as well. So European Union is already having their own digital competition law. In 2020, I think around they have come up with the legislation and they're also making a lot of improvements in it. So we are looking to make a law on it and committees are working. But the question is whether we should take the experiences of other countries or that the law should only influence that in India what we are making is going to get influenced by those factors or that we consider for this the local factors also because now the law is supposed to address the concern of the jurisdiction. So the criticism is that we are more relying on what others are doing than what we require, that it may backfire us. So I request Mr. Samir Gandhiji or maybe Toshiji to address this question, whether what would be the right approach for the bringing out this digital competition law.
Good morning, everyone, and thank you, Dr. Baila, for this, and thank you, Diksha, for setting out this context. I think the question about taking inspiration from other jurisdictions only comes because there are only few jurisdictions who are thinking about it. So the point number one here is that anyways there is no global consensus about having ex-ante regulation for digital markets. Because this is an evolving area. Yes, digital markets and digital economy are a reality and a lot of people and countries are talking about it. But is ex-ante the only solution? Maybe there is no global consensus. That's point number one. Coming directly to your question, should India be inspired? See, taking inspiration and studying other things is different from applying what is applicable in other jurisdiction to your country. Your priorities in every jurisdiction has its own priorities, and we are in an era where, in the inaugural session we heard remarks from the dignitaries about we are looking for a forward-looking economy where a startup ecosystem and a digital ecosystem are going to play a big part. So when you come up with any set of laws and rules that can impact not just the big techs that where the clamor is all about, but may also impact your local startup champions who are in the digital market. So a country-specific, your priority-specific assessment is required. So I'm fully with Diksha when she says there is an empirical study needs to be done and on the impact that it can have in country. So that itself makes it a localized issue. It's not something that you can take from a Europe or a America where they may have a different priority. More closer to this would be like, for example, Japan and Korea do not have or are not even talking about any ex-ante regulation because they may have different priorities and how they want to look at their digital markets. So my take here would be, and suggestion, not suggestion, maybe just to, I'm sure the committee is also looking at it, that what we want in India, and is it aligned with our policy framework, should be the guiding light in terms of whether we want to go ex-ante way and not because something is happening in Europe or America.
One more factor when you access all these platforms, like you tend to enter your details, and one of the another big setback that even youngsters in these days are not accepting that these platforms captures your data. So one of the serious factor that the law needs to address is this data privacy in the digital markets, because whenever you fill any form or anything that you enter into any kind of apps, that you are first required to register yourself. So now that many of having this view, a negative view on this, that though they knows that they have to enter this detail to get access to that app, but while entering itself, that they are still hesitant, that the platform is capturing my data and all. So knowingly this is inevitable that you have to regulate this. The law definitely will go to regulate. But the question is that you have that negativity that I am entering my details into these platforms, but there is no other option for you to continue with it. So this law is somewhere required to address this issue, the balance that citizen is apprehensive to enter, but at the same time he wanted to access that platform also. So if the law is made, this law is to be made in a very unique manner and outside the Competition Act, because these are the issues probably the law may likely to address also in days to come, because the moment the law is made, the litigation starts on this first factor. So I request the other panelist, Samirji, to address this issue, how to remove this negativity from the users.
Thank you, Masacham, for inviting me, and it's a pleasure to be on this panel. Thank you also for that very vast question, which can cover a multitude of topics. But I think, if I may, just in the framework of the conversation that we're having on this panel, deflect this in the context of the digital competition law, I think I'd have two observations, and coming straight from your question. The first is, I don't think we should be looking at, that proverbial golden bullet which is going to cure all problems with respect to technology. I think there's comments have already been made about the need to balance technological developments, which of course brings a lot of advantage, with of course its potential misuse. So I think data privacy, there are various aspects of the use of technology in everyday life which will be regulated in one way or the other. So there is, as we know, that the government is also thinking very strongly about data protection, data privacy. Now, whether that should all be encapsulated within any one law, my answer is probably no, right? Because as much as youngsters would like their details not to be entered into, they're also the ones who are benefiting greatly from whatever, they've got pretty graphic images on Insta Reels or TikTok, etc., etc. So there is a trade-off, right, between that you make at every time between your own data and how you use it, and that is something for privacy regulators to look at. But whether that falls within the realm of what we're talking about here in terms of the digital competition law, I would imagine not. But also just very quickly to reflect on what both Diksha and Turshit mentioned, incidentally I agree with much of it, which is that I think we should take a step back and say that, look, do we at all need an ex-ante regulation? I think the committee itself, which has been constituted, in one of its terms of reference has been asked this question. Ironically, the very next question is that please provide us a draft of the regulation, which kind of makes the first question moot. But I do think that the committee will be well served by asking this fundamental question: is ex ante at all required? Or is our so-called ex post mechanism under the competition law perfectly good? One wise woman once said, or man, that if it ain't broke, don't fix it. And I do ask myself this question once in a while, which is that what doesn't our existing competition law mechanism have that we need an ex-ante approach? Because what we will be doing potentially is drawing a red line in the sand. Think back to ancient Indian mythology, if you may, or the Lakshman Rekha. This one size fits all. When you draw a line in the sand and said that if you self-preference you are inevitably going to result in some sort of a bad effect, also skirts over the issues that both Diksha and Toshit have, which is that different strokes for different folks. You might need to self-preference if you're a food delivery platform, for example. You're advertising on your food delivery platform, you can buy food from Swagat. Now, you are going to also make some money out of having the delivery guy being the food delivery. So, I mean, it's either it's a tie-in or it's a preference because you're offering only your guy who's going to complete it. So, I think in short, to answer your question, which is that I'm not entirely convinced that our existing ex-post mechanism is inadequate. I think timelines are a factor. Markets may tip, and therefore ex-ante regulation may be something that we require. But to address timelines, perhaps we should be trying to fix this in a different way than yet another law and yet another regulation. We're all mindful of India's experience with the license Raj. So greater regulation is not always the answer.
In most of the cases, when you access these platforms, that you get to see the platform, for example, take Amazon. So I want to buy a suitcase, for example, that I'm looking at. So I have a lot of options when I type that what the kind of product I'm looking at. The survey, the Amazon also have its own sellers there. Like for example, that they are not only facilitating an outside buyers, but they also have their own sellers as well. Means the Amazon own, you can say that from their own companies. So now when I see a product that the first list when I type it, that I get to see all the products of the service provider. The Amazon own companies, for example, parent companies. Then I look for more research, then I'll get to see what I want. For example, I'm looking at a brand, for example. So when these platforms operate in that condition, that they only show the first attempt that only those, what they want to show it. So that is only getting reflected, but what I am looking at, I have to go to little deep research into it. So now this is where the competition or issue comes. So they try to elevate their own firms, the parent-related firms which are supplying similar products, so that I may try to first get attracted to it. So how to regulate them in this context? Because again, the big tech companies are very few that you normally access. So how, if a law has to be made on this, then how this kind of issues may be addressed? So I request Madam Diksha if you have any comments on this, because these are the tricky questions, but at the same time, you have to go and access those platforms. There is no other way. Yes.
Thank you so much, Mr. Rao. Again, I think this is something on which we could chat for a very, very long time, so I'll try and keep it very crisp. This pretty much follows on about the comment that Samir made on self-preferencing. It may be a concern at times, but equally it may not be a concern. And it's definitely not something new. We've had, back in the day, we've had issues of private labels and how they were placed in grocery stores. It was a big issue being discussed across UK. So it is, digital sector generally does not present any problem that we haven't seen before. The paradigm within which the problem is operating might be a little different because it's a different technology that we're dealing with, but these are not new issues that have arisen. And I think following from that comes the question that if the issue is not new, do you need a new tool to address that issue? Or is your current toolkit sufficient? And I would think actually that self-preferencing is something that regulators in India, regulators outside, in fact the Amazon thing that you raised is something that is has been examined by regulators outside India. So not to talk about the merits of that practice, but generally the fundamental concept there remains that there might be benefits associated with certain practices which need to be taken into account. We currently have a legal ecosystem which is considering these issues and addressing these issues. I agree with Samir that the timing of how soon or fast the issues are being addressed is perhaps something that can be worked upon. And we have, now we have mechanisms within the competition law that are currently deployed, like interim measures, or can be deployed in the future, which is settlements and commitments, which actually might help address that problem as well. So to paint it all with the same brush and say all self-preferencing is wrong, I doubt if that would be the answer. And even if you were to do that, we have to wait to see how ex ante in a couple of places where it's been implemented works out, but it doesn't seem to be self-executing. It is not like I've said this is bad, so we've had the commandment of thou shalt not steal for very long. People are still stealing. We still have a legal system enforcing it. So I don't know that absent a self-regulating mechanism, having a new law which mandates something not to be done, how effective it will be, I think we might end up dealing with the same problems that we are dealing with today.
And as a disclaimer, so we use for discussion purpose the names of certain companies. So don't take it that we are straight away addressing question to them. That is only for academic purpose, okay, for discussion. Right, the next question is, if we come up with a law to regulate these digital markets, so how the law should look like? So I think I request Samirji to answer this question, that if at all that we come up with a law, how the law should look like?
It should look good, because looks do matter. No, jokes apart. I think, look, as lawyers, we're all trained to say that the devil lies in the detail, right? I don't think that in the 10-15 minutes that we have on this panel, we're going to be able to come to, an agreement on the nuts and bolts. But assuming that, ex ante was the way to go, I'm a big believer in keeping it local, addressing Indian problems, but equally, if we have models out there which have worked, which have not worked, there is absolutely no reason why we shouldn't at least look at those models and either choose to disregard them in their entirety or, for that matter, adopt some of what they have. So while developing this so-called Indian approach to ex-ante regulation, I think, if you were to look at a few jurisdictions which already have these laws for the purposes of an academic conversation, you'd say, well, I mean, if we are all kind of agreed on this panel that, a one-size-fits-all red line / Lakshman Rekha approach is not what we want, then perhaps the European experience or the European style of regulation with their Digital Markets Act, which kind of lays down a clear list of thou shall not, may not be the way to go, right? Whereas if you look at, for example, what the UK is considering, their CMA, it seems to be a little bit of a hybrid approach where there are a couple of principles of what you should not be doing, and thereafter how it is actually applied, how the discipline is actually applied, is subject to studying each one of those markets to understand the nuances of how food delivery might be different from, for example, taxi aggregation or so on and so forth, right? Because each of these are fundamentally different business models. So my sense of what this law should look like is that it should provide for justifications, right? It should provide for, look, my business requires me to tie in or bundle, right? The example I gave you earlier about it's ridiculous to, buy something from, Swagat or Sagar or whatever else it is and then expect, Zomato to hand it over to somebody else to deliver it. So I think the two go in tandem with each other. So I think there are some business, kind of justifications which should be offered. So I would stop there. I think from an overall architecture perspective, allow for businesses to provide for justifications why a self-preferencing might look bad, but it is not in their context, right? And do not have a one-size-fits-all list of 14 things that you cannot do, because I think that's the very antithesis of how digital markets work, right? It's almost like catching a crook when he's already bolted, which is that the 14 rules that you have today might then become 16, might become 18, because things will constantly evolve. So I think less prescriptive is better.
Now my next question is to Toshiji. A competition law, whenever you investigate, the first question comes is, what is the relevant market? the how to define, this is one of the, dilemma, even the traditional model. So how, when you are going to address this digital competition, so what are the factors that it might influence more than what we have today to define, what could be the factor to define this relevant market, because the customers might have been spread even beyond the borders. So is there any difficulties that we may likely to face to address this issue? If you are comfortable, sir, kindly address that. What would be the factors which might influence in defining the relevant market?
I think the answer here is that relevant market definition has been part of the Competition Act so far. And going just by the statistics, in just about last 3-4 years, Competition Commission of India has done or studied, either started investigation or closed about more than 30 cases in digital markets. And so my take here is that in relevant market definition, this, with respect to digital sector, is nothing too significantly different, just in terms of market definition. And when I talk about CCI's experience in defining relevant market, these are, even in digital space, it goes to multiple sectors, from e-commerce to platform services like online travel aggregation, food aggregations. All of these, CCI's basic principle has been about substitutability and the factors that are laid down in the Act itself. So even for digital sectors, market definition I don't think is much of a issue from the existing standpoint. I think what is required is that from an ex ante perspective, we're talking about digital competition or something. Again, I will say that, look, I agree with Sameer that if we were to go this ex ante way, then the law has to be less prescriptive. And the point here to make here is that even your zeal might be to look at big tech. I think it all started with like regulating big tech. But when you're into policy making or a law making, it's not just directed towards a set of people. Right? Unless you come up with a very narrow criteria, which is a targeted criteria, but if you are objective about these criteria, it may end up covering a lot of your upcoming sectors. Like for example, a Naukri.com or a Book My Show. These are all Indian startups, and if you were to define markets, they would all be maybe one of the big players in their narrow segment. And if there is an ex ante laws giving them a prescription of things, what to do and what not to do, it may actually act as a disincentive for these guys also to innovate. I mean, as a larger principle, ex ante may have a red herring on innovation generally, but it can impact your local players also. So just in terms of localization or point of view also, there has to be a conscious effort to keep in mind what are we trying to define. Because this is in continuation of how, if we were to have a law, what criteria to hold or not hold.
Just to add to that also, I think it's important to bear in mind that one of the reasons why, at least in the past, there has been a urge or a movement towards ex-ante approach is also because the Commission is sick and tired of spending time defining relevant market. Right? So in some sense, the hope is, at least for some, that moving to an ex-ante DMA style approach, you will do what they have done. You will define a set of 14 core platform services. After that, they will decide whether within those platform services you are a gatekeeper, and that's the end. So actually, there is no need to define a relevant market under the ex-ante approach if you look at the way that the Europeans are doing it, or I mean, it's debatable about whether the British call themselves European any longer, but the Brits are doing it under their law. So honestly, the relevant market seems to be, you've hit the nail on the head, and so has Toshit, which seems to be one of the key reasons why competition authorities are saying that, look, we're done. We don't want to spend, hot tubs with economists deciding what relevant markets are. By then, markets would have tipped irretrievably. So bring us a solution now. So in some sense, this is a knee-jerk reaction to, I would say, the failings of competition regulators for some time.
So considering the time factors, we would like to take some questions from the audience. If you have any questions to the panel, please. Any specific questions on digital competition law? We don't have the law, but we are looking to make the law. So what do you think? You have any specific questions on this from anyone? Yes.
Hello. Yeah. Hello, this is Advocate Prerna, and greetings to everybody present here and the panelists. Well, I do not have any question per se, but I would like to express my views. I'm in agreement with Mr. Toshit Chandelier. What I feel is, like what we've been seeing in criminal law, in matrimonial laws, when you focus on a particular act, then you tend to get into a kind of your approach is very focused on that particular segment, and finally what ends up is that you get into conflict with the other laws that are still in prevalence, like we've seen in the IPC, the POCSO, then we've seen in the Family Courts Act and the other matrimonial laws. So what I feel is that this law, instead of making it a specific law targeting a segment, we can have a general law, and then the incorporations can be into the specific law, so that when it is read with that specific law, the provision doesn't become redundant. That is my suggestion. Thank you so much.
Any other questions? Yes.
Hello.
Good morning. About digitalization, the digital way, what I would like to say is I don't want to go to digital as a technology. What I would like to say is truth or facts not causing damage to others. Okay, unlawfully causing damage can be business or anything, or a loss which is unlawful. Somebody delivering truth or communicating truth through digitally, and that should get into the digital protection law, that this truth should prevail. Truth should prevail, and all laws should be designed to communicate the truth, and anybody communicating truth or which is ethical should get the freedom in this country, should have the liberty. This truth, ethics, values should prevail. There it is lacking. India is lacking when it comes to truth, ethics, values. It is lacking, and the law is getting misused or not being helpful to the citizens because it is either missing in the ethics or values or in the truth. Even freedom of speech or liberty should have the truth.
Yes, sir. Anything related to the session?
I'm talking about this digitalization, even in digital form.
Okay,
the truth has to be respected.
Yes, sir. We have heard. Thank you. Thank you all. Yes. Last question. Yes. Anything related to subject? Yes. Yeah, please. Yeah, please. The last question.
Hi, I'm Hari from Econ1 Research. So my question is, does AI-driven business practice lend itself more to ex-ante regulation? Because, AI operates at a speed and scale much faster than humans can. You can tip a market in a few weeks, a few months. So would that present a better use case for ex-ante regulation?
I actually would think that given how new AI is and how little experience we all have as regulators to determine what kind of an impact AI can have, ex-ante regulations, which are very prescriptive in nature, might actually be more damaging and hinder innovation. So it needs a little more cautious set of probably guiding principles, very broad guiding principles, as opposed to prescriptive ex-ante.
Okay, thank you.
So thank you all. Thanks to all the panelists for their addressing all the queries and addressing especially my questions related to this, for which there is no sufficient evidence to answer, but it's a law is evolving field, and thanks once again to all the panelists for the addressing all the questions and participating in the discussion. Thank you.
Thank you very much. That was a stimulating discussion we just had. A round of applause for all the learned speakers. We'll have a group photograph. Please step forward for a group photograph. Kindly keep the applause going, ladies and gentlemen. Thank you very much. Moving on to our next session on M&A Unveiled, Navigating Growth and Global Opportunities. Please join me in welcoming session moderator, Advocate G.P. Madan, Co-Chairman of ASSOCHAM Task Force on Corporate Restructuring and M&A and Managing Partner of Madan Law Offices. Can we all please welcome Advocate G.P. Madan on the stage, our session moderator? Okay, sir, sure. He'll be joined by the key panelists, Mr. Hemant Sahai, founding partner, HSA Advocate. Kindly keep the applause going as they join me on stage. Dr. Sanjeev Gemawat, Group General Counsel, Vedanta Group. Mr. Sameer Chugh, General Counsel, Games 24/7. Mr. Hitesh Mehra, Legal Counsel, Regulatory and Investigations, Google. A round of applause, ladies and gentlemen, for all our learned speakers, esteemed panelists on the stage. And I now hand over the session to session moderator for further proceedings.
Thank you. And thank you, ASSOCHAM, for this event and giving us this opportunity to interact with you. We have high-powered panel with us. And before this, friends, let me share with you, we have one of the fantastic inaugural sessions today. And I'm starting from where the inaugural session ended, though Mr. Hemant was part of that, but I don't know other panelists were there or not in the inaugural. So for their consumption, our Additional Law Secretary, Mr. Mani, he gave wonderful tips, though majority of them was not new to us, but whenever we narrate them, we feel happy, we feel elevated. He talked about our economy, which is a $3 trillion today, and he said very shortly we are going to be $5 trillion, and maybe in a decade to come, we may be around $30 to $35 trillion by the end of 2035 to 2040. And as far as ease of doing business place is concerned, last rating was done in 2020, that was we at 63rd place, and he said if the rating is announced today, we may be around 50th place, or maybe the top in the first 50s. Lot of legal reforms are happening in the country as per him. The compliance burden is reducing. Decriminalization of offenses is there. We are witnessing that. Number of obsolete laws are being deleted, are being repealed. We are having transparency in governance. Why I'm saying this, I'm connecting all these dots with my session. With all of you. Then recently we had our Remediation Act, we had Digital Data Protection legislation, we have amendments to Commercial Courts Act, entry of foreign lawyers, change of curriculum for our law courses. But besides all this, what we have is, we have our geopolitical situation in the world, which is really disturbing. We are seeing wars in some parts of the world. Then we have technological disruptions and innovations both. Use of artificial intelligence, and last but not the least, in some parts of the world, we have recessionary trends, and in some part of the world, we are having growth. If we talk about India, our growth is really fantastic. But if we talk about US and Europe, in some of the countries, we are seeing recessionary trends or the economy is not growing. But wherever the economy is growing, even yesterday, Jeremy Powell of Fed chair, he said, our economy is growing, so therefore, there are going to be inflationary trends, so we have to increase the rates. I mean, it's a dichotomy. Economy is growing, so inflation is growing, so therefore we have to increase the interest rate. So if increase in interest rate, then economy has to come down. And on the other hand, if you see today, just an hour ago, not even an hour ago, RBI Governor Shaktikanta Das addressing somewhere, and he has been asked a question, what about you think about the interest rate? Will they come down? In India, we are talking about rates of interest coming down, and in US and other countries, we are talking about rates of interest are going up. Now, looking at this entire domestic and global scenario, looking at the regulatory framework within India and outside India, looking at the finances available, looking at the inflationary trend, looking at this economic scenario everywhere, my one question, common question to all my panelists, how do you find and where do you find the opportunities in M&A sector, particularly in India or in global scenario? What are the opportunities in M&A? What are the opportunities for corporates, and what are the opportunities for we, the professionals? So this is a common question to all my friends, and I'll start with Dr. Sanjeev Gimawat.
Thank you, Mr. Madan, for interesting question. Yeah. So thanks, SOCHM, for inviting me to share my views. The question which Mr. Madan has put is undoubtedly interesting. He has put the question with certain numbers, and I think the answer lies in those numbers and that his preliminary statement itself. The way in which I see the M&A activities evolving in the times to come, I see that M&A activity is nothing but a reflection of the state of economy of a nation. And the state of economy of a nation depends on multiple external factors and internal factors, as Mr. Madan rightly pointed out, that in today's world, the kind of activities which we are seeing, they are amalgam of multiple factors, and just let's take the example of the last year itself. While from a global standards, we were having US recession, we were having European Union market, again, a recessionary trend there, Russia-Ukraine war. And so globally, M&A activities were not motivating. But at the same time in India, the M&A activities were at its peak, and from a volume and value standpoint, I think we have achieved significant as far as the last year is concerned. So it certainly reflects that the activities or M&A activities are reflecting the state of economy, and the state of economy, as he rightly pointed out, today we are talking about $3 trillion economy. In the times to come, we are talking about $30 to $35 trillion economy. I don't know to what extent that number should be given credence, but then it's still assuming for the hypothetically that if not $35 trillion, even if we achieve 10 or $20 trillion economy, it essentially means that there would be lots of activities in the commercial world, and in the commercial world, activities are dependent on largely three factors, the way in which I'm seeing the market. One is the technology, innovation, and artificial intelligence. That would be leading the lots of activities in the commercial world. And second would be the finance, because any economic activity is dependent on two main factors. One is finance, and the second is innovation. Now, to achieve that, if I talk about the Indian context, if we want to achieve that $10 trillion economy, we need these two factors, innovation or the technology, and the second what we need is the finances. Today, from a nation standpoint, we are lacking both these things. So essentially it means that there would be lots of activities whereby the investment would be coming into India, there would be lots of consolidation, and so is the case as far as M&A activities are concerned. Now, when I say that last year, despite of the global trend, a negative global trend, we have achieved significantly, I think that there are a few inherent reasons for that. And those inherent reasons are that those inherent reasons would continue in the next 10, 20, 30 years. One is the domestic market is huge, a huge population. The number two is that the China plus one supply chain strategy that worked very well and the world is focusing on India. Third, I think that there is, as Mr. Madan pointed out, that the legislative framework or the regulatory framework has been, has certainly improved from various initiatives. If I talk about the, for example, foreign direct investment, FDI regime has changed. Today, there is an automatic route process which was introduced last 20 years. I think that in the last couple of years, in terms of defense, telecommunication, and insurance sector, that has opened up. I think from an inbound investment standpoint, overseas investment regulations, there is a complete overhauling as far as those regulations are concerned. Today, the outbound investment also, I think a lot of reforms have taken place. So I think from both inbound and outbound investment standpoint, the legislative framework is impeccable today. I also think that from a stressed assets standpoint, and which is also one of the major market as far as M&A activities is concerned, I think from a legislative framework standpoint, we have one of the most matured legislative framework in the form of IBC. So I think various reforms have happened, and they would all be pushing as far as the M&A activities are concerned. Certain sectors, because I would like to focus, is that there would be lots of M&A activities. So what I see is automobile sector or auto ancillaries. This is one sector which looks to me very, very promising. There would be lots of consolidation as far as startup activities are concerned. The third sector which I am very fascinated about is the mines and mineral sectors, particularly when the critical minerals, we might be doing good as far as ease of doing business is concerned from a ranking standpoint, but at the ground level, there are still issues. There is a lack of consistency as far as the regulatory or the regulatory or the court proceedings are concerned. I also feel that the inconsistency is to such a high extent that industry is always disturbed that what would happen as far as the process is concerned. IBC, despite of the best framework, I think we failed in terms of achieving the outcome of the IBC. I think that I would just limit my comments on here. Thank you very much.
Looking at the time scenario, I think these may be opening and closing remarks both. Actually, you talk twice you have touched IBC. And IBC is very close to my heart. But I'm a staunch supporter of IBC, if you ask me. Though people talk about the haircuts, 50% haircut, 60% haircut, 90% haircut, all these are media news. If you see at the ground reality, and if you compare it with the liquidation value of all those units, as per IBBI figures, the recovery is 177% of the liquidation value. So by no means that's a wrong figure, a bad figure. And in this all CIRP matters, more than 2.3 crores has already been, more than 2.3 lakh crores has already been recovered. And that's not the end. Actually, we are not looking at the cases where the applications have been filed, but before admission of the applications, 25,000 plus cases have been settled, and the underlying debt there was 8.3 lakh crores. That is actually the achievement of IBC, which is not being highlighted by any media. Because IBB has created a fear amongst defaulters. Now, whenever an application is filed, the corporate debtor runs back to the lender and tries to settle the account. And there actually the victory of IBC. And 8.3 lakh crores is not a bad figure. Please, please, please.
I completely agree with this comment that the mindset of the industry has changed significantly. Today, nobody can dare to default as far as the financial obligations are concerned. There is no doubt about it. But IBC, as I said, that despite of the best of the legislative framework, we have not done justice to this for the simple reason that that was one of the single most important statute which was providing definite timelines. We have not respected those timelines. The judicial innovation and intervention happened to this extent that still there are cases pending for last many years in the courts. So I think that that is a negative part of it. I completely agree. As far as the liquidation value and the recovery is concerned, this is over 170%. But if I compare it with the earlier regime and the today's regime, the figures are the same. Earlier also we were at around 39 to 40% of the recovery as far as the total value is concerned, and today also is the same. So from that standpoint, perhaps the numbers are not that motivating. Thank you.
Okay, I'll refrain from giving comments on the judicial setup. Even day before yesterday, everybody knows Supreme Court has also passed certain strictures on the judiciary, on NCLT and NCLAT. So now I come to Mr. Hemant Sahai. The question remains the same. And what are your comments on the basis of your practical experience?
Thank you. Thanks very much. One thing I'd like to tell a lot of my colleagues and younger colleagues is that to be a good legal practitioner, one also needs to have a good understanding, knowledge of economics, finance, and specifically geopolitics. And this is coming back to what Mr. Madan said in his opening statement. So in the context of M&A, if I have to draw all these elements together, it's quite clear that India is sitting at the cusp of, greatness in many ways. So look at BRICS. I mean, the global economy is being driven by BRICS to a large extent. But Brazil is recovering from the Bolsonaro scandal. It's going to take some time to get back to even keel. Russia, of course, as we all know, is engaged in a debilitating war, which is going to drain its own, I would say, resources. India is sitting in a good spot because our neighbor, China, has dug its own grave in many ways. And the China plus one policy is now becoming quite a big policy issue for most of the nations across the globe. South Africa relatively is still a small economy. It can't make that much of an impact. The second part is that India is and will remain and continue to be a net importer of capital. Now, what's driving that import of capital, of course, is what's going to drive your M&A market. Because capital is going to come in either direct FDI or M&A acquisition of existing businesses, and of course whenever there's an acquisition of a business, there is a drive to grow it, which means further capital inflow. What is driving this capital import and incentive to bring capital into India is again a combination of factors which Sanjeev also mentioned briefly. There's a large domestic market. There is a certain level of innovation and entrepreneurship that I think we need to be proud of. Startup ecosystem, globally we are number 3, though of course, the gap between the first and second and us as number 3 may be significant, but still it is something worth emulating and talking about. So there is innovation, there is a market, there is a demand, and therefore that's what's driving our growth. Whatever the numbers, 7%, 6%, long term, medium term. The other thing about ease of doing business and all of those things are driven more by policy. And I think while the government is conscious that it needs to make doing business easier, there's lots more that can be done. And to that extent, I of course agree with Mr. Gamawat, Dr. Gamawat. There's lots more that needs to be done. Now, as professionals, when we talk about assisting in this M&A process, getting a part of that opportunity, so to say, as independent practitioners, as parts of large corporations, we are all kind of facilitating and making that happen. Now, so long as India is going to depend entirely on its own internal consumption, there will be a time when I think that growth will start slowing down or plateauing, and we will therefore need to start looking at outbound investment and outbound acquisition. Whether the time has arrived or not, I think is up for debate, because I think while we talk about a very significant population, the middle class is also a large number, 350 million or thereabouts, which, by the way, just to put things in perspective, if you put North America, US and Canada together, our middle class is equal to that size. Now, there are other questions that, is this middle class really, does it have the spending power, etc. But, all of that reflects in not just GDP numbers, that is sometimes illusory, but actually the per capita numbers. The per capita numbers are growing, and they will continue to grow. And I think part of it has got to do with just the sheer size of our population, because the GDP is a reflection of the number of people. But also, there are many other issues of, skills. So I think if you are talking about M&A market becoming vibrant, and without getting into statistics, there are many things that need to be done within the country, which is a combination of government policy, but also improving our skills in terms of getting industrialization, manufacturing ecosystem into the country, etc. India will always play to its strengths. Services is really one of our strong points. While we've been, when I say we as a country as a whole, have been putting a lot of focus and emphasis on Make in India, the results are still, the jury is still out, is still open on whether it's been a great success, a success or not at all. In my view, of course, it's a momentum that has been created. And looking around, there are many government policies that help and assist. And hopefully, to that extent, there will be a very, very strong push to internalizing manufacturing, which can then become a good supply chain alternative to China. Now, when you put all these things together, and like I said, it's not just about pure law, it's about geopolitics, it's also understanding a certain amount of demographics, the economic principles, and financials. As a lawyer, as a professional, our ability to engage with other finance professionals, our ability to understand simple things like balance sheets and P&L accounts is what will really improve our skills as M&A lawyers. In my experience, clients today are very discerning, and they know what they want from external professionals, including legal professionals. And if we approach a client merely as a provider of pure, simple legal services, then the tendency is to commoditize that legal service, which leads to a whole lot of other distortion in the legal market, because then it becomes a price war, and it's a race to the bottom as to how I can actually do a laundry list of due diligence effectively, whereas what the client wants is value. And therefore, the client is willing to pay a premium for value, provided you're able to demonstrate it. That value comes in multiple ways. It's not just a question of my understanding of balance sheet. That, of course, is a job of a finance professional. But how to integrate that in the context of identifying risks in the M&A, for example. Some of these risks are systemic, where technical experts, financial experts will obviously contribute. But as lawyers, many a time, if we do not have enough visibility or expertise or I would say experience in the underlying sector, then some of the legal services tend to become very theoretical and high level, which of course then reflects in the kind of pricing one can expect to get from the client. I think coming specifically to some real life instances, we were recently involved in a large M&A transaction on the sell side, and which really dragged for a long time. But I think in the end it was a successful sell, and it was one of the largest in the renewable space in the recent past. And I believe we as lawyers for the sellers were able to help and assist in the process more because we understand the underlying sector very well. And we were able to deal with a lot of the risks or assumptions that were made by the buyer to be able to enable them to price that properly. And these are the kinds of things that I think as legal professionals is what the ecosystem should encourage and develop. Thank you.
Thank you for your optimistic comments. Now I come to Mr. Hitesh Mehra, who is a legal counsel, regulatory and investigations with Google. What is your experience, your comments?
Thank you, Mr. Madan. I was noticing before the panel that Samir was taking frantic notes, so I need to give some time to him to speak. So I'll back to him. So I'll keep it short. No, not at all. I'll exercise my right there. So when it comes to M&A, I think the focus always gravitates somehow towards the Indian market, and it's time for us to focus more on the outbound investment. And therefore, I think the more India improves as an attractive market, the stronger launchpad it creates for itself as a good, investor destination for investing in other host countries. And I think a lot of things have been falling into place for that. The regulatory framework, I think, is a real positive. The economic tailwinds are one. I think, but there are some areas of concerns too. One is I would say, the general reputation of many of the business houses globally has to be notched up, and I think that's also something which develops in cadence over time, and it is. There are healthy signs, but not a lot needs to be done. The biggest problem, I would say, in terms of creating this launchpad is for the last 2 decades, the amount of investment which has gone from the private sector into inventiveness and creating an inventive ecosystem is I think the focus is increasing. There is the graph is clearly looking up, but I think we are coming from a period where this wasn't a focus at all, and the focus was too much as India as a market, and without inventiveness you cannot be a market leading force investing outside India. Then after that, I think the elephant in the room, as everyone recognizes, is geopolitics, and I think that's where we as lawyers play a very important role. From all our experience, we can surely say that if we don't have a pulse on the geopolitics, market entry in other jurisdictions is a very, very slippery slope. And the lawyers' advice has to hold fort there. China, Iran, and a number of other countries, Central Asia, one has to have a real good pulse of geopolitics. This is the entry, and one needs to be slow and circumspect, especially now, because every country's decision making is self-centric, it's multipolar. And therefore, once a pivot happens in a country's policies, it takes a lot of time for it to swing back, and all that affects our business decisions as business houses. However, once a market entry is made, the way the investor has to look at that market has to be like a citizen and an ecosystem player. What does the business bring to that country, to its citizens, to the business ecosystem and the market it operates in? And this ethos of the company runs into every decision that it makes on a daily basis. If you don't get that right, you will have problems adjusting into a country. You will end up being transactional in your approach. You will end up dealing with rent seekers who are resident in that country, and you will not be able to really extract long-term business value and contributing to the land. And I think that remains true whether we talk about the digital world or capital-intensive industries. That approach to outbound investment remains constant across industries. That's all I have to say. Thank you.
Thank you. Now I come to Mr. Samir Chok. Samir, in addition to what the question I asked, I have one more question. You may address that if you so like. According to me, the way we have been reading recently, the way the GST notices are being issued on these game companies, I think a number of gaming companies may shut down their doors and they may be acquisition candidates. Maybe huge, on the one hand it's a negative, but on the other hand it's a huge opportunity as far as the M&A arena is concerned. So what are your comments?
Sure, thank you. I think the challenge of going last is that a lot of it has already been said. So you have to really pick what you need to say, but let me talk about both things. But just on the general trend first, I mean completely, I mean most of it was said, but there's just a few things that I thought it should put out is that while M&A is going to be there always, but there will be kind of ups and downs that will come. Because if you look at it today in the first 9 months, and this is from the ET, I mean none of my derived figures, but from the Economic Times, basically M&A activity is down by about 56% in the first 9 months of this year. It's down to about 65.6 billion. The domestic M&A activity fell about 60% to 44.1 billion. Essentially, finance has been the one sector which has contributed to the majority of the deals. Even that has gone down significantly. Inbound M&A fell about 47%. And if you look at it, really from PE-backed M&A, that was sitting at about 11.1 billion, which is down about 60%. So obviously, this trend at least shows that the M&A transactions per se is going down, and a lot of factors that do kind of contribute, which is essentially what was all said about the part of recession, cost of borrowing has gone up, there is a huge amount of inflation, so therefore obviously the amount of the capital available and what you get in return is challenging today. Now if you take all of that, what that actually opens up is an opportunity. Now, therefore, you can get better deals and you can get deals that are probably making more sense in the long run. Because a lot of times what happens is that the M&A is done more from the perspective of trying to consolidate, strengthen your numbers and say, okay, I want to just expand it. But now, with the current market trend and how it will probably play out in the future, is that people will look at differentiated deals. People will look at opportunities which will actually grow into the bottom line as opposed to just turning around and expanding your capacity. So people will look at other businesses which will help, given the fact that maybe some of the traditional businesses will slow down. And so it's more about, kind of adding to it. So I think tech is a big opportunity to me. That is where it will happen. Consolidations are bound to happen in the next, kind of year or so. I think markets which are really end use will benefit. So if you look at, kind of India consumption market, that story will still stay. Some of the other markets across the globe where consumption is high and is bound to grow will be the areas to look at where there will be potential, kind of growth and therefore an opportunity to pick up or buy things. Of course, clarity, ease of business, regulations, all of that is very important because unless and until you have clarity and unless and until you know what you are required to follow and how you're required to follow, I mean, that will always be a problem because you don't put in money in uncertain places. You put money where you make sure that there's some certainty and I can predict what's going to happen. Therefore, I'm kind of bound to grow my money. I mean, that's really how I see the trends happening. To talk about the whole gaming sector, I think, the gaming sector is a sunrise industry, or at least was bound to be that way unless there are certain headwinds, as we call them, that are coming our way. And clearly there are about, I mean, I don't know if people know these numbers, there are about 950 odd gaming companies in the country. Only about 100 of them are meaningful. A lot of them are small startups with a lot of potential. But clearly the whole GST regime and the way it has gone, there are challenges. And therefore, the sense there is that a lot of these companies will probably shut down because if you are to turn around and pay 28% of GST on your entire, kind of rake or the value of deposit or the bet, I mean, it is much more than what you actually earn. And the fact is that consumers are also very conscious. They're not going to take up the full thing. And if they do, I mean, you have a huge risk of this moving to really gray market operators. Today morning, there was a news item, or yesterday, where it said that just the IPL season and the World Cup season, 892,000 crores has been put on bets with illegal operators outside of India. Without GST. And so just take 28%, there is about 390,000 crores of loss that the Indian government is currently sitting at. I mean, this is on the presumption that the entire money should have otherwise been put in India. So, I mean, you look at the staggering figures and look at what's really, you know, kind of coming up and whether it's affordable or not. Clearly, I think, clearly, I think a lot of companies will shut down, which is really, you know, opportunities to buy. And therefore, you will get a lot of these smaller gaming companies who have extremely high talented people, very strong tech, and you know what I would say is a very good platform, which is kind of, you know, going to be the future. And therefore, a lot of these opportunities, at least in the gaming sector, I see, there is going to be similar trends even outside of India. And there are places in the world where, again, there are headwinds for the gaming industry. The more mature markets like the US, the UK, Australia, I think, you know, kind of their opportunities will be lower, but some of the other growing markets, the opportunities will increase. So clearly, I think a mix here, I mean, a lot more negative, the way at least the trends have been. But as I say, when things are very negative, that's where the positive starts, which means that the opportunities to really get into M&A, and therefore people who are conserving cash and the ability for them to go and turn around and pick up good deals, and therefore plow back into the economy is there.
Thank you so much. I think time is not there for the second round, but I think we should invite at least 3 to 4 questions from the audience. And I request these should be questions and not the observations or comments. Yes, please. No question? Okay, if no question, then observation, please. So, yeah, let me go to Shweta only. Shweta, what's your observation on that? You also being an M&A expert.
No, thank you so much. Actually, it was quite an enriching discussion, and then it really, you know, gave some insights into the geopolitical situation. And I think the statistics that Samir has given is really eye-opening for us, because we think the things are going hunky-dory. We don't realize, you know, till you realize that 60% M&A has gone down, which means a huge amount of business actually is not really happening. But what I see as a trend is now that the M&A is happening more towards the insolvency side. I think, you know, there are a lot of M&As happening on the IBC front. So probably that is found to be a more lucrative way of doing M&A than the regular M&As that we used to have. So that is the one observation that I had. But then, yeah, there are a lot of questions which are coming in my mind. Why is it happening in the first place? Samir did attempt to, you know, respond to some of them, but I think as a panel also probably we could, you know, ask those questions on why has, you know, this starking change which has happened. 60% less M&A is something which probably we need to deliberate in these kind of sessions.
Your observation ended with a question.
With a question.
Yeah. Can I answer part of that at least, you know, because I did some research and that's why. I think, see, if you notice the trend of the M&A has kind of been continuing to go down. The start point of that was really, you know, kind of post-COVID as the prices went up, as the inflation went up, clearly there was a rate increase. So that was the start point, which was then followed by the whole Russia-Ukraine debacle. And that, I mean, you know, I think it was misjudged. Why? Because everybody thought this is a month battle, it'll all get over. Nobody expected it to, you know, last for like a year plus, and it's just continuing to go on. And therefore the impact. So if you look at it, I think the first impact that happened because of these two things was Europe and the US. Now that's where a lot of the money comes in when you start to look at M&A or you start to look at investment. So clearly if the money there is drying up, the M&A activity is bound to go down. So I think those were really the start point of it. Now, where it ends, I don't know, because currently, you know, it's a cycle that we are stuck in. On one side, because there is inflation and it continues and the prices are going up, and now with the whole Israel and you know, Palestine thing coming up, that's another one. So we don't know, and I think people have now started to think about expect the unexpected. Earlier, you could predict saying, "Ye ek mahine mein khatam ho jayega," ho jata tha. Now I don't know where it will go. So therefore, I think there is a huge caution, at least within the businesses, within the people who have the money to turn around to you know, get into M&A. And therefore, as I said, the other part being the differentiated thing. So if you're still looking in traditional just to increase your base, not very clear if the consumption is there, and therefore, you know, kind of that'll make sense. The whole way the AI has come in, the whole tech piece moving, there are a lot of moving parts. And in a moving part scenario, an M&A activity will always be the first one to get impacted because you don't know how your return will come.
if I may just add a little bit to what Samir was saying. So I think firstly it is cyclical. I mean, that's quite clear. We've seen this downturn in the past also. 60% in value terms or volume terms, I mean, those details are there. But I think just to add one or two things. So at least in the Indian context, and of course in other parts of the world, the M&A will be driven by capital, which is essentially in the US and, you know, a large amount of it in Europe. During the COVID, US literally printed $8 trillion to just distribute free within the country to, you know, get them out of COVID. Now that came back to bite them in the form of inflation, as Samir indicated. So obviously, as a result of that, you know, our startup ecosystem in India suddenly got cash starved. And that's because the entire money investment in the startup ecosystem was coming from the US, from the Valley. So these kinds of things happen. Russia has obviously aggravated it. To a certain extent, what's happening in West Asia will have an impact. If nothing else, on sentiment. We all know M&A is driven also a lot by sentiment. It's not just about money and opportunity. So the overall sentiment right now in the investor jurisdictions is to just slow down, internalize. So, you know, the kinds of returns or, you know, interest rate hike in the US incentivizes them to just put that money within the US economy itself. So I think some of these things will keep balancing itself. So there are positives in terms of, in India sitting literally at the cusp of, you know, a big opportunity of China +1. It's up to us to be able to capitalize it. For that, we need to do several things internally within the country. So, but I think it's cyclical. From a slightly medium-term perspective, I think some of this activity will increase. India will have certain sectors, and I can tell you that, you know, energy transition is one area where, thanks to what's happening in Europe in terms of carbon tax, the amount of investment that's going to get into green hydrogen, ammonia in India is very, very significant. That'll happen in a year or two.
I have only one comment, Shweta. I think things are not that bleak. As far as the world economy is concerned, perhaps answer is yes, because of multiple reasons. But as far as India is concerned, we have performed very well. Certain aberrations would always be there. Post-COVID, we enjoyed that period in terms of the multiple deals. Even the subsequent 2022, India has performed exceedingly well in terms of volume and value both. I think if I remember correctly, it was around 996 deal or 976 deals, and perhaps the total amount involved was $270 billion. So it was not bad. Certain aberrations would keep on happening. One, you know, Hemant rightly pointed out, because of some other issues also, consolidation happens. And just to give you example, that ESG has also become a reason for transactions, for M&A activity, besides technology and finance. And why ESG? For example, if one entity like Holcim, Holcim's exit from the cement business, globally they have exited from the cement business. So definitely in all jurisdictions, all those cement assets were on the block. And that's what happened as far as India is concerned. So there are multiple reasons why M&A activities, you know, happen. In one jurisdiction, if M&A activities are not happening, it doesn't necessarily mean that it would not happen in India. For example, China +1 strategy. That would be helpful as far as India is concerned. Yeah, thanks.
Thank you. Thank you all my co-panelists, my dear friends, for a short, crisp and a wonderful session. Thank you very much. Thank you.
Thank you very much for a thought-provoking session. I now request session moderator, Advocate GP Madan, to kindly present a memento to Dr. Sanjeev Gemawat for being the jury for National Legal Excellence Awards. A round of applause for Dr. Sanjeev Gemawat, Group General Counsel, Vedanta Group. Thank you very much. I request the panelists to please step forward for a group photograph. Thank you very much. Ladies and gentlemen, quickly moving on to our next session, which is on transforming disputes into economic opportunities, India's resolution path. Please join me in welcoming session moderator, Mr. Amit Goyal, Forensic and Integrity Services Partner, EY India. Can we have a round of applause for Mr. Amit Goyal, session moderator? On stage, joining him are key speakers, Ms. Shreya Jeet, Advocate and Public Policy Head, Arnest Law, Advocate Venkat Rao, founder and managing partner, Integrate Law Offices. Mr. Sanjay Gupta, Head Legal and EVP, Jubilant Ingrevia Limited. Mr. Kirit Javali, Advocate, Supreme Court of India. Requesting the session moderator and key panelists to kindly be seated so that we can quickly start the session 3, as we are already running a bit behind schedule. Ladies and gentlemen, a round of applause for the key panelist and session moderator as they join on the stage. Mr. Amit Goyal, Ms. Shreyajit, Advocate Venkat Rao, Mr. Sanjay Gupta, Mr. Kirit Javali. A very warm welcome to all of you. Thank you very much for joining us. I now hand over the session to session moderator, Mr. Amit Goyal, for further proceedings.
Thanks a lot for this opportunity. So, hello everyone. So, I'm very delighted to moderate this session where in the next hour, we are going to discuss paradigm shift in various legal and dispute resolution practices which are adding to the economic growth for India. I have a very eminent panelist with me, very diverse panelist, who will take us through with their respective point of view that how India's legal landscape is changing in terms of technology, in terms of regulatory reforms, and various organizations, the way they are dealing with the disputes resolution process. To start with, my name is Amit Goyal. I'm a part of EY's Forensic and Integrity Services, and I focus on dispute resolution as a financial expert. To introduce the panelists, I'll start with Mr. Kirit Javali. So Mr. Kirit Javali is an advocate in Supreme Court of India. And before that, he was the founding partner of Jaffa and Javali Advocates. And after that, he has now joined Arna's Law and handling various disputes and arbitration matters. Mr. Javali has a lot of experience in relation to corporate finance, FDI, arbitration and litigation, as well as intellectual property. Mr. Javali is a LLB from Leeds University, and he has also spent his stint in UK under very reputed law firms. Now moving to the next panelist, Mr. Venkat. So Mr. Venkat, I found his profile to be very interesting. One thing I found is that he's not just a law professional, he is a finance and management professional as well. So that's very interesting about Mr. Venkat. Mr. Venkat is also a very renowned practitioner in consumer and commercial arbitrations. And also he looks after various matters in relation to management, finance, and again, arbitration and litigation. Now moving on to Mr. Gupta, Mr. Sanjay Gupta, a very dynamic professional, having 35 years of experience as a GC in various reputed Indian as well as multinational companies. Now, one very important thing about Mr. Gupta is that he's a person who can kind of make you learn while you work with them. So, very dynamic personality, ask as many questions as much possible and be very interactive. Now moving on to Ms. Shreyajit. Ms. Shreyajit is part of RNS law firm. She's heading the policy advisory practice there. And her area of expertise is environmental law, social law, as well as disputes and arbitration, international dispute resolution mechanisms as well. One more important thing about Ms. Shreyajit is she is harnessing technology, and her approach is kind of very progressive in terms of how technology can make the dispute resolution as well as the legal practice better in this environment. So I'm very excited about this. With this, I will quickly move on to our session on this, and I'll start with Mr. Gupta. On the question that the focus of dispute resolution mechanism is very conventional nowadays. You know, there are two parties and they kind of do a very conventional thing. They enter into a contract and they try to resolve their matters. But I think Indian legal system and Indian economic growth requires some contribution from the dispute resolution mechanism as well. And that is something which I would like to ask Mr. Gupta, that what are the impetus that why these reforms are happening and how this is changing the landscape in India.
Thank you, Amit. Good afternoon, everyone. My role is a little difficult being a GC, and I have to be politically correct, and also when I see the changes in two shapes and forms, what is happening is, we all know digitization, access to mobility, access to smartphones, meaning everybody we see is able to do digital transactions. So that change is it touching upon the dispute resolution process or not, is where we, I think, need to focus this discussion. My sense is, what I look at, okay, 35 years, what I used to do then and what I am doing now. Last week I was in a mediation in a dispute which was in a court in US, and I was not in US, I was sitting in India in my office and undertaking the dispute resolution representing my company as one of the parties. Now, have I experienced that across board? No. I still am required to run to Delhi High Court when I am representing a company. So that change, I am sure, is likely to happen. In terms of our law catching up, yes, some changes are taking place. So we have the Commercial Courts Act, Consumer Court Act. We have ability to raise issues at Samadhan portal for the MSME. We have ability now, though it's not in all states, but industrial dispute resolution also, there is a Samadhan portal in few states. We have e-lok adalats. We have mediation centers. So the thing is, it is picking up, and these are the areas where I think we see a lot of growth happening, which is for the right, meaning earlier we used to hear, and we still hear Tariq pe Tariq, but then is that going to end? I don't know that, but I do see that some of the elements, and especially the focus which the current government is doing on online dispute resolution, I think these are commendable steps. We all are now actually demanding what I would say online hearings. So the Supreme Court recently, in fact, said that you cannot deny a lawyer from representing in court on a virtual basis. So to that extent, we are now actually demanding it as a right rather than as a facility. So I think those are the trends I see.
Quite wonderful. So some of the very good points Mr. Gupta has raised about what government is doing, setting up various centers. I just want to connect this point and move on to our next panelist, Mr. Venkat Rao. That how this dispute resolution reforms are making an impact on the economic opportunities in India. And specifically, one thing which is a barometer, which is considered and very highly marketed also, that improving ease of doing business in India. So how specifically the legal landscape is changing that scenario?
Thank you, Amit. Thank you, Asusham, for having me here. Good afternoon to all of you. Now, Amit, it's a very important proposition that we are talking of as to how quickly and how a dispute could be resolved. You know, the reason is a dispute is not good. I'm a litigation lawyer, but still I say dispute is not good. It's expensive. It is time-consuming. It impacts your business. So it's not at all good. So what one sees today is most of the companies or most of the contracts invariably do have these alternative mechanisms, meaning thereby generally an arbitration clause is evident. And what one sees is that the first recourse, at least to most of the corporates and most of the, whenever somebody would like to enforce a contract, has been on the arbitration side. Looking at the impetus on the side of the government also, the stress to have alternative resolution, including, the recent bill of mediation, is all, now an act of course. So the thing is that one would like to move on and look at alternative dispute as the core and the quicker way of resolving the issues. But yes, one issue that probably Sanjay ji has been pointing out is that even these alternative mechanisms are quick. Honorable Chief's, one quote or one mention that I would immediately like to say, that he said, it has to be, instead of delivery of justice, it has to be service of justice. That's the mindset that needs to change. And unless we have that, there would be delays. And yes, one appreciates that the Arbitration Act, by way of amendment in 19, has brought down and fixed up the timelines. Mediation Act is one thing that has been brought in, and online, dispute resolution is being encouraged. So one would say that we have a focused approach towards, and I think we will see an improvement in it.
No, in fact, when I was looking at that, the earlier statistics said it takes 4 years to kind of resolve any litigation in India minimum. So I think there's a long way to go, but I think.
Yes, see, one statistic that I was, looking at is, which is very interesting. And even in civil courts, they were comparing from 2020 to 2022. The average time period was about maybe 1,200 odd days. It came down to 656. I was wondering whether it was because of COVID or was it because of some seriousness on the part of the courts. But yes, even if as a practicing lawyer, I can say, even in the judiciary also, there's been a change in mindset. They would like to have things disposed of, which is a overall improvement in the outlook itself.
No, very fair comments on that. Now moving on to some specifics of and some of the hot topics, and I will move to Mr. Kirit. Mr. Kirit, you spoke extensively, in the media, and also you wrote extensive articles on dispute resolution mechanism when the country went into lockdown. How far along have we come in terms of adoption of technology, and specifically some of the digitization in this space?
Thank you, Amit, and thank you, Asucham, for the opportunity to be present here. I think there's a misconception that generally, I'll just give a little background, that computerization really took place only in the recent past. And everything changed only during the pandemic. That's not really the case. It's been a slow journey, but I think from 1990 onwards, this entire computerization in the judiciary started taking shape, culminating in the national e-governance policy and e-courts phase project. So a lot of changes have happened for the better. But yes, it's been a slow journey. And I think it's also the stakeholders who have been resistant to change. But I think all that changed with the pandemic. And then the Supreme Court decided that our system will crumble if we do not act quickly at the outset of COVID. And that's when the suo motu decided that the system will continue and it will be through online video conferencing facilities. And I think it was a remarkable experience for everybody. While some matters may not necessarily have been adjudicated very well online because of the complexity and the volume of papers, documents. But largely, I think it did definitely help in terms of providing access to justice, saved a lot of time and cost for litigants who have to come from different parts of the country, especially for Supreme Court matters. And I think a lot of lawyers, also the younger lawyers, were provided an opportunity to exhibit their skills. So it did definitely provide a path for many to experience what online justice system is. Having said that, I think ODR is here to stay, and there are various sectors like banking, housing, all these sectors will definitely, for smaller disputes, even the capital market SEBI, I think they all, for investor grievances, all these disputes can be resolved online rather than coming to court. And the only challenge which I see is that there's no regulatory system in place yet, though there's a Niti Aayog report which said that we must have the ODR system in place and a policy has been brought out. But I think more impetus needs to be given and awareness has to be brought about, and for people to have confidence in the system, though there are some private stakeholders who are pushing it very hard, and I think it's a good way forward so that the courts can take up serious matters and time is used more effectively. Thank you.
Yeah, in fact, I was listening to some of the earlier panelists in morning, and one statistics which they gave is that India is the third largest economy to support the startup ecosystem. Now I do a lot of work for the startup companies, and these startup companies, if you see, are thriving on technology, e-commerce, B2C space. Every month they are adding millions of users on their platform. How do you think this ODR would help these startup companies where they are kind of having a very tight runway on cash because they are growing, as well as they are adding a lot of users on a daily basis, and these users are not the direct consumer of the judiciary system. They are like normal person, either students or college goers or young professionals. So how this ODR mechanism will change the game?
I think we're still at the nascent stage, but definitely in certain retail sectors or you take, for example, Amazon, of course, it's a very mature company and much older in the market. They have a mechanism in place, but it's early days, but I think definitely startup companies would do well to adopt the ODR system. And they're, of course, all bootstrapped at this stage, but going forward, I think some mechanism can be evolved, and startup companies should be advised to explore the ODR. It's akin to emergency awards, so something which companies exercise those options at the early stages. So yes, this is still work in progress, but I think there is potential.
Great. I'll pass on to my next question to Ms. Shreyajeet. So Ms. Shreyajeet, with the passing of the Mediation Act last month,
yes,
this is again a welcome step towards some reforms in the dispute resolution space. With respect to the regular litigation process, what changes do you anticipate in that?
So idea is, when we speak of mediation, it's not that as lawyers we were not aware about it, or as litigants people were not aware about it. Now you make it more formal. You produce a bill which was initially, brought in only to make things better. But idea is, again, it's a two-way road. When I speak of lawyer community also, when we proceed forward in a sector which is informal, there are things like our clients not paying us when we go for these sessions, but when there is an act in place, you can introduce it to your client. As I mentioned, Indian Mediation Act 2023, when it comes with its 65 sections, 10 clauses. Now, government takes a step, right? Now, it comes to us, how we introduce it to our clients, how our clients get to know about it. So it starts off with education, starts off with awareness, then accessibility, utility, receptiveness. Any new thing when it's introduced has to be taken forward with some amount of hand-holding. You can't expect a phenomenal, acceptance in the first few years. I mean, we have India Mediation Center in Hyderabad. They're doing amazing work. Tariq Ahmed is there, and he's my senior in profession. And I know how it started off, 10 years back when people used to talk about it. ADR arbitration was seen as the next big thing. All students will be looking up at LCIA, SIAC. But now when mediation is introduced, for a level, even arbitration has become cumbersome. So when mediation is introduced, you also tend to take it towards technology. You talk about online mediation, clients, they feel that, oh, we can do it. Today, when I work with startups, honestly, when we speak of startup culture, and, my previous panelist who was there, I was so happy he brought in the whole concept of geopolitics. And, any lawyer cannot operate till the time they don't know geography, they don't know culture, they don't know sociology, they don't know the polity. So I do believe that, today, if the startups, the moment they get funding, they go to Singapore. Why they go there? Because somewhere or the other, the legalities are more structured. I feel India is a developing country, but expectations from India is that of a developed country. So, what we do has to be two-way. When I speak of for a, when we were the demographic dividend, right? Yeah. So it has to be a two-way road. At every step, even, as lawyers, and even as litigators, we think that there's a responsibility on our shoulder to even tell people, to take that one step forward. So yes, that is my take on it. But yes, technology is there to stay. It is the only way, ODR I say is the only way that it will enhance the step forward. Because when you make it less cumbersome, is when the acceptability comes. Cost, I feel like lawyers should always, they're always told the cost will come down. Hello, we are making the effort, at least, reward us a bit in that. But yes, definitely compared to litigation, as EODB, you guys were talking about it, Venkat sir was talking about EODB, ease of doing business. Yes, India did tremendous job. We, out of 189 countries, we were ranked 163. Then we came down to 63. But enforcement of contract, we are at 163 still. That is exactly why you need to introduce reforms. So yeah, that was my take.
No, very wonderfully said. In fact, again, I will move to Kiri, and I want to connect that, even the law ministry was optimistic about amicable settlement. That would not only help preserve, but improve the relationship between the parties. Because what I see that business is usual and litigations and disputes are part and parcel of the job. What I believe, I think these kind of practices, mediation and amicable settlement, is also helpful in the relationship building between the parties. So what's your kind of...
I think, again, as Shreya just explained, mediation, of course, it's a two-way street and it's here to develop further. We always had these provisions in the CPC, by way of Section 89 of the CPC, and parties could always opt for mediation or conciliation at some point in time. But again, the traditional mindset is, I'll see you in court. So, notwithstanding all these mechanisms have been introduced, and definitely over the years, many attempts have been made to popularize them and make people understand that, how much time can be saved to thrash out the differences and resolve your disputes. And again, re-energize the relationship, which obviously has gone down south or sour. So I think the mindset of mediation also has to change, because it's not about, also I would say from a practitioner's point of view, it's generally, you feel, oh, are we going to refer it to mediation? What happens to my practice? So a lot has to change from the fraternity as well. An effort has to be made from the fraternity to say that, we are going to resolve. It's a different skill set also which is required. It's not just two people sit and just mediate. So there is, what is it at stake? It's not just about some figures which are being thrashed out. That's the typical mindset in India. Okay, what's the quantification? How do we arrive at, what is the relationship been? So number of factors which need to go hand in hand while we mediate, and what comes out of it. So it is equally effective mechanism in India as compared to arbitration, which was always thought that we'll resolve disputes through our own mechanism, but it did become cumbersome and it did become costly, and less said the better. Although my own take is institutional arbitration is the way forward rather than ad hoc, and that will probably also attract more foreign investment and give more confidence in people in the system in India.
I just want to add to what Mr. Kirita just said. It's right, absolutely right. The fraternity also need to actually look at mediation as, while we suggest to client what would happen to the practice of ours will not serve us in long term. I mean, absolutely right that the awareness has to come through, and that awareness probably as councils, it is one of the responsibility of our fraternity to actually give this as an option to clients. For a resolution, a longer resolution, I think the best way of doing it is probably mediation. In fact, in the mediation bill, I recall that initially, even when we went through to the Rajya Sabha Standing Committee, we had mentioned that it should have a, mandatory pre-litigation mediation was, suggested. But then somehow, somewhere along the line, it has not come through. But yes, mediation is probably another big thing that is coming forward. As a fraternity, we should support it.
In fact, just to add on that, I was at Hyderabad recently regarding construction disputes conference, and one of the lawyers there, that's why I mentioned that we lawyers also have to act. She says, I have 2 rooms in my office. One is a mediation room and one is an arbitration room. So you decide which room you want to enter. Accordingly, then we will resolve our disputes either through mediation or adopt arbitration. So I think it is a mindset change within the system and stakeholders, which will probably help things go forward. Thanks.
No, also I would like to add on some of the reforms, in fact, which I have seen in the international arbitration, which I see less or non-existent, which is the concept of hot tubbing in case of experts. I think that's a very important reform which India should also bring in, because what I've seen is that a lot of time experts are being questioned on pointers which may not be relevant of their assessments. A lot of the credibility related issues, a lot of their credentials related issues, and some of the issues which both the parties may agree. Some of the pointers both the parties agree, but they are just for the sake of cross-examining the expert. Each party ends up asking some of the questions which may not add value to my point of view. So how this hot tubbing also kind of growing, getting any perspective on that, if it is acceptable in India?
So Amit, before I go on to the experts, I'd like to add to the debate which was going on between Kirit and Venkat. See, from a GC point of view, what I am seeing is that encouragingly a lawyer talks to the other side's lawyer. Now that is happening across the globe, but it is denounced in India. So if my lawyer speaks to the other side's lawyer in India, I feel that there is something fishy. But when my lawyer in US speaks to the other side's lawyer, in fact, in Europe, we were having this arbitration, and this guy, my lawyer, says that, look, can I talk to this other side's lawyer on this? I said, no, but you should do it in my presence. So there is a huge mindset change which is needed here. In same thing in the US, meaning there, I say that, look, we need to file this application, or we need to do this. We need extension of time, for instance. So he said, okay, I'll pick up the phone, I'll call this other side's lawyer, and we can organize that. That should not be a problem. So I said, then what happens if next time they want it, and then you'll again decide unilaterally, or you'll consult me? So there is a huge kind of a difference I see how things have evolved. I'm not saying it's good or bad, I'm just saying that it expedites things. So coming back to the experts. Now here again, there is a difference in practice. So recently we had a use of an expert. The issue was in India, so we appointed an Indian expert, and the deposition was in US. So the case pertained to US. We supplied some goods. Accident happened and all that. So I had a doubt that because of race and culture, will the Indian expert firstly feel intimidated? Will he feel so the questioning of the expert's credentials, that happens across board. So it's not that, okay, we only do it, everybody does that. In fact, they even go to the extent of questioning what is the emolument you've paid to the expert. And you have to transparently share the agreement between you and the expert you've appointed, or so the way out people say is that you do it through the attorney-client privilege and let your lawyer appoint the expert. So in that case, you will not be required to share the details of what is the engagement. So that's one, I say, a difference which happens. The other is even the Indian experts, they are very reluctant to appear in a deposition outside of India. Even though virtual hearings permit that they can do it sitting in their comfort, but at the same time there is still reluctance. So we had the opportunity of a professional who was a leading person in transportation technology in India. But he was very reluctant. So I had to counsel him that, look, you don't have to worry about it. So that is one, there is an inhibition here. And then I'm not saying that there is no racism, there will not be any racism. All those are also there, but then generally it's not, meaning it's decreasing.
Again, I will now move to Venkat. At Venkat, we talk about a lot of benefits of this ADR as well as the online dispute resolution mechanism, but still, what kind of challenges you see, specific challenges in this resolution mechanism?
See, I think in the previous questions we did touch upon them, even Kirit did and Somi did. See, the basic, the challenge is, having an infrastructure. One is definitely an infrastructure. If you talk of, ADR having adequate centers, and especially in maybe tier 2, tier 3, I don't think we have that kind of an infrastructure. Of course, apart from that, the awareness, as Shreya was just mentioning, awareness in itself, even though it is there, but it is somehow, even today, especially on the ODR side, the comfort of appearing is still not there. So which is, a mindset change that needs to happen. And then, of course, we have other challenges of execution, so on and so forth. I think in the previous panel, somebody was mentioning of the execution also. So these challenges are there, but then, yes, things are moving, as Kiritji has just mentioned that, Supreme Court has said that why not have online, and in fact, it was in Punjab High Court matter only that came up, and then across the board they gave notices. So let's assume, looking forward, I see that these challenges are maybe, more of mindset. This is changing and will certainly change.
Yeah, I think it's, so before we conclude, I have a couple of questions also, which are quite important for, one is for Shreyaji. Shreyaji, how do you see the role of experts evolving in this whole scenario?
So again, I say, when we speak of mediators, it is again a job where one has to also train, right? Mediation as a practice has existed, but when we speak of India today at 2023, the kind of sectors India is catering to, if I am there, even I need to have that understanding, right? Sector specific. Today, if I'm dealing with agri-tech, if I introduce that clause of online mediation, there's a, I learned so much with all the people. I was in Bombay, I'm a product of complete Indian value system, and education system. So I say that India is so diverse. Like, experts, language comes as a barrier, even when we communicate. Yeah. So I think that when we take care of small things, bigger things actually fall into place. So language barrier, considering India is so diverse. So even as experts, if I am not able to work and understand something which is happening in Maharashtra, but the funding has come from French investors who are sitting, abroad, and they have a contract with us and we are working for them. My thing is, fail there, we need to have that that sort of inclusivity, that way of working, that we can be approachable in diverse manner. Then again, when we speak of digital literacy, even in Delhi right now, I won't vouch that all our phones will be working all the time. When we speak of network connection, India is still an agrarian economy. Rural sector holds the largest chunk. I am very happy with what we did, post demonetization, we did tremendous, but the work is still, we still have to make and do more, right? It has only started. So 55% of India is without internet connection when I check the last data. And when we speak of 55% who are without proper formal digital connection, I also mean of which there will be way more number of people who don't know what is formal digital literacy. I mean, do they know how to do net banking? Something very basic, like net banking, or even how to go and check the status of the case, or how to file if there's a consumer complaint. Consumer courts are very, very tech handy. I mean, like you can file anything as per your, from your point of view. You can draft, you can just approach that platform. MSME is doing a wonderful job, but again, when we speak of different sectors, I think experts need to come with their sort of, their sort of understanding on the law firm page. If you want online mediation, probably there is this one resource center, where you can come and you get your knowledge over there, and you can, we guide them. We create a form. Then again, the second and the most important thing which I say is like, considering the amount of service provider that India is, we are a very service-heavy economy. I do believe that if we have the intent, we can really do that. In like coming 5 years, we can make exceptional changes. I mean, just a little away from the topic, we were talking about tech sector. So how the funding which is actually coming, like a lot of startups who work, not all startups in a bubble, they're not. There's some who are doing very well. And so, everyone who's working, they know how agri-tech sector is being slowly recognized. That's because coming 30, 35 years, it is going to face a lot of food shortages. And when I speak not only of India, I always speak for Africa, South Asia, and at the same time Latin America. Now, when the investment is coming there, the work starts today. How are we defending the legalities in those, online mediation? Because this field-specific people will be in the various geography. So how am I devising that? Not just in India, but also, across the global geography. So yeah, it is a lot of work, but experts, when they come together, we work better. So I think they have doctors without borders. Probably it's time lawyers become without borders too.
Of course, very nicely concluded. Absolutely agree on that. Before I get another chat, so just a last question to Kiri. How will allowing foreign law firms in India, how will allowing foreign law firms in India will change the game?
This room full of lawyers, you'll get the answer from each one of them here. But anyway.
Everyone has their own.
I think definitely we have to move forward, and there are of course pros and cons in this decision. But going forward, I think it will be a welcome thing, and we'll have to obviously, the Bar Council of India has come out with some regulations, 2022. And at the moment, only foreign lawyers are only permitted to advise on foreign law, and foreign arbitrators can participate and come and go. And there are certain restrictions in terms of the time frame for which they can be around. Definitely we can benefit, but I think we will have to balance the interests of the lawyers in India and also integrate. If you want to be a $1 trillion economy, which the government says, then we will have to also open up in a phased manner and permit foreign lawyers to practice. Of course, there has to be reciprocity, and that's where I think hard negotiations will have to take place. And there is a great opportunity for Indian lawyers also. There are lawyers who are already setting up overseas, have done that in the past. So it's not easy to integrate in any jurisdiction overnight. But I think there is also an opportunity, but at the same time, we need to balance it out. Thanks. I was expecting your answer, sir. You've been a votary of against it.
I'm Dr. Lalit Bhasin, President of the Society of Indian Law Firms and immediate past President of the Bar Association of India. We have had the benefit of having some negotiations, some discussions with the Bar Council of India. Earlier, we were opposed to the entry of the foreign lawyers, but since 2014, we have taken a very consistent stand that now we are ready for the competition. I would rather call it co-opetition. It is cooperation and competition with the foreign law firms. But the issue arises whether they can be allowed or they cannot be allowed, and the onus is on the government. The Supreme Court judgment in 2018, Bar Council versus Balaji case, has held that only Indian citizens can practice in India, and practice of law includes not just litigation, it also includes transactional work, corporate work. More importantly, what the Supreme Court said, even practice of a foreign law in India is also prohibited. So as rightly pointed out by Mr. Kirit Javali, that two exceptions were made, that is fly in, fly out, as we also do for our clients when we visit Europe, UK, Singapore, Japan. Second is in matter of arbitration, but there also the Supreme Court has put a condition that Bar Council will frame rules regarding the participation in arbitration proceeding. Therefore, what we have advised the government also in our several meetings with the Law Ministry, also with the Bar Council, that amend the Advocates Act. Unless you amend the Act, you can't overcome the effect of the Supreme Court judgment. Anyone can go and get a stay order based on what the Supreme Court has said. So that is one aspect about foreign lawyers. They are welcome, but at the moment they can't come till the Act is amended, you see. And that onus lies on the government and the Parliament. I'd just like to touch upon one brief aspect, because I am also chairman of the Chartered Institute of Arbitrators. Litigation has failed in India. Totally, the system has broken down. Admittedly, by the government, by the Chief Justice of India, 5 crore cases are pending. So some PILs are decided, some political cases are decided, some important cases of which obviously involve either Adanis or Ambanis or some other people. Those are decided, but what about the common people? Their cases are pending. And I shared a platform with the Chief Justice of India when he said, we are having digitization, bringing in technology that will facilitate. I say, yes, that will ease the filing of cases, but that will increase litigation in the sense that ease of filing will not result in ease of disposal. Disposal has to come from here, not from the computers or the laptop, not by AI, because each case has to be decided on the facts. Therefore, litigation has totally failed, broken down. Arbitration has failed to take off in this country, and I can say that with some daring certainty, as experience you see of being an arbitrator, ICC and all that. It has failed to take it. It has become more expensive than even litigation, more prolonged and more uncertain because of judicial interventions at almost every stage. We have very eminent lawyers here. I think they would agree with me. Therefore, answer, as rightly pointed out by Shreya, mediation. But for mediation, that is settlement, samjhauta, resolve your disputes. That is in our culture, that is our heritage. The panchayat system, the consensual form of administration of justice. So we have forgotten the justice part, we are only relying on the law part, you see. That is the problem. Therefore, a mindset has to be changed. First mindset to be changed is that of the government. As rightly pointed out, you see by Mr. Sanjay Gupta, that if they talk to their counterpart in the other, the people think there must be something fishy. Now we advise, you see some public sector undertakings, and when we advise them to settle the dispute, they say, Dr. Bhasin, if we settle the dispute, tomorrow there will be a CBI inquiry. Why have you settled this dispute? There must have been something more than, therefore let the court decide this, you see. Therefore, a mindset of firstly government has to change, then 60% cases will go away. That will reduce the pendency also. Thank you.
Sir, thank you for Amit, I'm taking your mic, so 1 minute. So 2 points. Sir, thank you for the overview, and just wanted to add one aspect because we didn't touch it. So, but it's not just that the lawyer can talk to the lawyer. It's the lawyer who can talk to the judge also. And the judge is not seen as, there is no black mark arising from a lawyer talking to the judge. So when my counsel told me that I'll talk to the judge, I said, is that permitted? So I'm saying there is a huge mindset set as you change, as you rightly said, sir. And there was one more other comment I wanted to make is, see this as a GC, we also feel that the competency of the lawyers who are here is much higher compared to what I see in the counsels I interact with outside. They are more money focused, they are more commercial. We also criticize many lawyers here who are money focused and commercial. But at the same time, I think the quality and caliber is huge. One thing which I also wanted to add was that, see, there is AI, there is machine learning, and there is blockchain. All of these, please don't brush it away. There are simple things like traffic challans. Now in New York State, they disposed of some, I think 40,000 traffic challans in a day using AI. So it's not that, I agree with you, there are some aspects or many more aspects in law or dispute which are much more requiring the brain and requiring the gray cells, as one may say. But there are these, meaning I also keep receiving, I disposed of a car 5 months back, I still get SMS about the challans on that car. So I'm just saying that these are the areas where I think a lot of these technologies are useful. We are using them in business. We can also use them in law.
Yeah, very well said.
I think when we spoke about the expertise, when the experts in mediation and when we speak of mediators, the new law, which is very short, but it does speak of having an Indian Mediation Council. Now, it is not clear yet how it will be structured, what licenses will be given to mediation councils, what sort of training will be given. So, when we speak of mediators also, I mean, again, it needs to be more definitive. It has to come with a proper structure again. I thought so wanted to say something. Nonetheless, also, very briefly, half of the time, I always say, 50% it's psychology, 50% it's substantial effort that goes into litigation. We speak of ease of doing business, let's speak of ease of doing litigation, which led to this act. Now, again, difference between arbitration, conciliation, mediation is something, half of the clients don't even know. They say how it is even different. When we speak of ADR, somehow they reach to the step where they understand alternative dispute resolution. Now, when you tell them that, okay, conciliation is where we want you to have, mutual good, relations, and then mediation is a little more formal, tickets not binding, but then the new act says that it will be binding, unless until you make an appeal. So, for us also devising differences so that we make it more approachable and more doable from our end is the first step as an expert, when we take mediation forward. But nonetheless, that's the way we will be working, and online dispute resolution is the platform to look forward to.
Yeah, thanks a lot. So I think just to conclude, I think it's a very insightful session by all the 4 panelists, and at the end, the inputs from Sir were very kind of helpful and to understand the actual meaning of reforms, which he said lies in the disposal of the matters. Again, a lot of things needs to be done, are happening. Things are taken very positively. In fact, when I joined this profession and now I see a remarkable change in flexibility, the way, at least in the arbitration forums, are operating. So I think way to go. But there is always plus from here, not the minus. And we are not stagnant, we are growing. As Shreyajit rightly said that we are a developing company with a developed mindset. And I think everybody behaves and consume like a developed country in India. while we are still growing at a very fast pace. So thanks a lot. Any more questions we'll take afterwards. I think we'll conclude it here. And thanks for hearing us and giving your time. Really appreciate it. I'm very thankful to all the panelists and the audience.
Thank you very much for a very insightful session. For more questions, you can connect with the speakers offline during lunch. Thank you very much. Please step forward for a group photograph. Ladies and gentlemen, our final session before lunch focuses on compliance to commitment, embracing ESG and the rule of law. And I will quickly invite and introduce our session moderator and key speakers for this session. Thank you very much. Please join me in welcoming Session Chairman, the legendary Dr. Lalit Bhasin, Advocate, Supreme Court of India, and Managing Partner, Bhasin and Company. He'll be joined by key speakers, Dr. Mukul Shastri, General Counsel, Cube Highways, Ms. Sandhya Tolat, General Counsel, Aarti Industry Limited, Mr. Pulin Kumar, Senior Legal Director, Adidas India. Let's all together welcome them with a thunderous round of applause. Session Chairperson, Dr. Lalit Bhasin, key speakers, Dr. Mukul Shastri, Ms. Sandhya Tolat, Mr. Pulin Kumar. Kindly keep the applause going as they join us on stage. Thank you very much, sir. A very warm welcome to all of you. And I now hand over the session to Honorable Session Chair, Dr. Lalit Bhasin, for further proceedings. Can we please welcome him on the dais?
My esteemed panelists, other worthy participants, my colleagues in the profession, whether in-house lawyers or external lawyers, ladies and gentlemen. This is a very important session on ESG, but it is also tagged with rule of law. I was reading in the newspaper today only, in Indian Express, a brilliant article written by Rohini Nilekani. It is Requiem for a Dying Tree. No living being likes to be uprooted, not people, not trees. So trees, you substitute trees for the climate change which is happening, because this article relates to a 100-year-old tree which suddenly fell down when there was a very strong storm, hurricane, and it uprooted the tree fell down. What had caused that was some construction work being carried on in the adjacent plot, deepening, you see, the going deep into the soil, and therefore weakening the roots, you see, of the tree. But then the people never gave up. They tried to bring back the uprooted tree and replanted it, and were successful in giving it a new life, you see. Just apply this, you see, to the present scenario that we have of what is happening today. We are like a tree, old tree, which should be venerated, but which has been weakened by pollution, by environment changes. That is what is happening today. And we are not conscious of our responsibility to the coming generations. And that is what people did when they planted back the tree, because they were conscious of the fact that it has to be brought back to life. And life, you see, means also the coming generations. And that is how, you see, the author ends it. It is a brilliant article. I suggest everyone should read it. You see, in today's Indian Express, he says, Vrishka Rakshata, those who protect trees will be protected by them. Workers nodded at the phrase. If this credo remains intact in our Samaj, we might yet save ourselves from the worst fears unleashed by our own ambitions. To paraphrase Wilson, E.O. Wilson, maybe we won't destroy our species' rich ecosystems to cook our development dinner. Maybe we will preserve our irreplaceable ancient forest and regrow our dying ones even as we build dams and highways. Then the requiem for any dying tree can also become a hymn for the emerging forest. So that is the significance, you see, of climate change, the hazards, the catastrophic changes which are being brought out. Therefore, the question as to what is the responsibility of business organizations, the corporates, apart from responsibilities of the government and the citizens and other things. But we have three very, very eminent panelists here who represent, you see, as in-house counsel, as general counsel, the corporate sector of India. We have with us Madam Sandhya Tolat. She is General Counsel of Aarti Industries Limited, which is engaged in manufacturing of specialty chemicals and pharma API and intermediates. And it is supposed to be a very highly regulated organization, and we'll hear more about the challenges that they face. Then we also have Mr. Mukul Shastri. He is the General Counsel of Cube Highways, which is responsible for road highways sector, inclusivity, and so many other things. Such a eminent organization. And then lastly, we also have Mr. Pulin Kumar, representing the world famous brand Adidas Group, you see, as the General Counsel. With these three very eminent speakers, I will not take more time, rather I would join you, all of you, in learning from them, because I feel that every conference I attend, every event I attend, there is always some learning which I take back and I try to absorb. Because I am not an expert in these matters. These people deal with the situations day in and day out. Therefore, I would request, firstly, Ms. Sandhya Tolat, you see, to start with that, because we would like to know from her as to what is ESG, what does it encompass, and the current challenges or impact on businesses with compliance on ESG. Over to you.
Thank you, Dr. Basim, for the warm introduction. Good afternoon to all my esteemed colleagues here and participants. So as Dr. Basim rightly introduced us, so I'm Sandhya. I'm the General Counsel at Aarti Industries Limited. We are globally #1 in specialty chemicals and pharma APIs. Extremely different manufacturing sector. You know, we hear of other commodities. To start with, the very basic nature of chemicals is that they are very hazardous, they are very toxic. They need a special level of technology and skill sets to be handled. So that being the nature of our business and linking it to our topic of today being ESG and compliance, I want to bring this up that as an organization, I think the first thing we truly believe in is that, our destiny is truly intertwined with the well-being of the society and the community. And therefore, what we do today should impact positively in the future. And with that theme in mind, even before ESG was, formally required by law and now formally required for listed entities, we have been imbibing the principles of ESG into our nature of business. Briefly just, I think all of you all know what ESG is, but maybe we hear it in bits and pieces and we relate to it differently in our jobs. So I think one is when we say E is the environment, and we all know that environment compliance is a must, but I think the shift that is happening today is not a reactive compliance where there is a law and you comply, but how proactive are you? And I think that is where the whole ESG framework plays a very important role. That's what attracts investors today, where earlier, what is the production capacity of a business or how good their revenues are no longer matters for an investor. I think the first question they want to ask, and which gets repeatedly asked in all our investor calls, is, what's your investor strategy? What are you doing on renewable energy? What is your sustainability policy? And large part, of that is what is now building trust into the future generations. So environment, as I said, is now being proactive and not reactive compliances. Social, yes, I think all corporates at some stage, even before it was mandatory, required by company law, was doing some bit of honorary work. But now there is a focus that while businesses are growing and being set up around community, the community care, development of the people, livelihood, education, health, sanitation, upliftment of women is a very, very core aspect. And governance, I see a paradigm shift again, because where governance was earlier looked at just a tick box and a compliance has been met, the focus now is on ethical practices and transparency, right? So I think you have to start being transparent as an organization. You need to be known as an ethical organization, because we are no longer in a day and age, and I think all my panelists before have spoken a lot about digitization, even in mediation, everything is transparent. So if you're not going to disclose it proactively, somebody somewhere is going to ask you that question. We cannot live in a bubble that I'm going to hide this, or my investors or shareholders in a listed company are not going to know. So I think that's a brief outline of what ESG actually today entails. So as an organization, if I have to speak for my organization, what we have done is we have actually built ESG as a part of our core business strategy. We have developed systems and processes around ESG where there is regular monitoring even at a board and a management level on a monthly basis. We have different locations. We have 19 plus plants. So at plant levels also, a lot of monitoring happens, and corrective and right and remedial actions are being taken month on month at a chairman and managing director level. So that's the level of interest that our organization is committed to. I think two things that stand out for us is that, and traditionally, right, all businesses have grown traditionally from being promoter-driven companies to now being global players, and therefore a shift that we are seeing in an organizational mindset. So it was a proud moment for us when we got the EcoVadis gold rating, which is essentially keeping a check on your sustainability and standards of CSR. And also we have a major change in customer engagement ratings, where initially we were at a B, we have actually managed to move to an A. And the reason being is that now it's not only about the people around you, but every stakeholder in your value chain, be it your supplier, your producers, your purchasers, all your vendors. ESG plays an extremely important role. And the first question is that what are you doing on ESG, And therefore we have taken very many initiatives in the last few years where we have focused heavily on greenhouse gas emissions. We have also, under process of creating our own plan under the science-based target initiatives, which is a UN-based collaboration which helps private sectors decide how much and how fast do they need to actually reduce their greenhouse gas emissions, basically trying to neutralize the carbon change, climate change.
It is not merely compliance with law. I think you also follow some good corporate governance practices.
Absolutely,
and
sir.
that
Actually,
is a change in mindset of
yes.
Yes.
Because being, as I said, our businesses are both specialty chemicals and pharma APIs, and we have US FDA approved lines. So actually, on the pharma sector, it's highly regulated. Some of you all may be catering to pharma clients or maybe from pharma sectors themselves, so may be able to relate to it. There is actually something known as good manufacturing practices, which each of our plant has to follow, and there are 6 months, once a year, FDA checks that happen because these are dedicated lines for highly critical medicines that we are making. So that's the level of compliance that we have to look at, actually not only in the Indian context, and because the nature of our business is also make in India, which is catering to everything from pigments, dyes, paints, you name it and you touch it and our chemicals are going into it. And a large part of our business is exports. We actually adhere to a lot of global best standards and practices which our customers expect us to.
That's very encouraging to know. Now we would like to know from Dr. Mukul Shastri, General Counsel, Cube Highways, as to how is the road infrastructure dealing with ESG framework, especially the inclusivity and social initiatives.
Thank you, sir. First of all, thanks SOCM and thanks Bhasin sir for having me here. And thanks to Mr. Rajendra Kumar for the invite. Absolute pleasure and privilege to be part of this panel discussion. As Sandhya has already explained that what is ESG, I will just discuss about infrastructure and what role we play in the infrastructure industry and ESG, what are our crossroads. Infrastructure, first up, is a very important sector, and there is, you might have heard from economists that the multiplier effect of infrastructure is 3 to 6, which means every single rupee invested in infrastructure will give a fillip to 3 rupees to the Indian economy. And with the new NIP, National Investment Policy, there is almost 1.11 lakh crores investment that is slated to be there by 2025 in infrastructure, which means almost a fillip of 3 lakh crores to the Indian economy, which is a greater push. So therefore, the sector is a very prime sector going to contribute to the dream of India becoming a $10 trillion economy in some time and then a $50 trillion economy by the Amrit Kal. So this is what the sector plays. Now, infrastructure is unfortunately infamous on all the 3 parameters of ESG. Whether it's environment, you may know that infrastructure requires a large kind of investment. Wholesome, an example given by Dr. Gemawat in the previous session, who has to sell its plants because of their ESG requirements, whatever they may have in the global scheme of things. So therefore, infrastructure is very infamous for environment. They are always carbon negative. So as S is concerned, the social part, again, infrastructure is being known to pay only minimum wages, or very biased towards in gender also. So it is infamous for those things. And likewise for governance also, infrastructure is unfortunately again being blamed because the payout is huge, the payback time is large, and the amount of money involved is huge. Therefore, there is a lot of possibility of poor governance there. And therefore, ESG framework has to be absolutely spot on so far as infrastructure is concerned. Now, coming to the question which Bhasin sir has raised, no worries, sir. So, interestingly, the sir has raised the question of inclusivity and the S part, and I was just hearing to what Sandhya was also telling about the environmental part. So, whenever we talk about ESG framework, fortunately, unfortunately, the focus is always on E and G. S always plays a very second fiddle role, a non-stacker role. Like in yesterday's inning, it was the role what Rahul plays when the Kohli got the century. So S is always the second fiddle. Sometimes I say they are like the heroines of 1980s, 1990s Indian movies, where the heroine role was just tick in the box role. Required, but just tick in the box, just to be the love interest of the protagonist, just get kidnapped and get saved by the hero. Whereas in Indian culture, women have always been very powerful. We have Navratri going on. So women has always been powerful in Indian culture. But then again, somehow that portrait was not there in the Indian movies. Similarly, S is a very important role to play in ESG framework, but somehow it has not given that importance which it should have. Generally, ESG means always environment and governance. The top 2-3 standards which are there even for ESG, which come to my mind right now. For example, SASB, one of the most popular standard for ESG framework, which is Sustainability Accounting Standard Board, which gives us various frameworks of how to report on ESG. Then again, if you see, the entire focus is on financial materiality. Obviously, there is a chapter on social, but then it is, I feel, not doing that justice to this aspect, which is very, very important. Likewise, you might have heard about polluter pay, 100 crore fines on oil spills, and likewise. So E, people are very scared of. Likewise, NGT is very active. Likewise, governance, we are very, very concerned. Regulators are very concerned with governance. But somehow, inclusivity and social, I feel is not that demanding or that threatening for corporates. They are doing CSR activities. They are doing lot for diversity and inclusion. But still, I feel lots and lots to be achieved even on that parameter. And more importantly, the mindset. As Bhasin sir said, for lawyers and entry of foreign law firms, it is about the mindset that is required to be changed. And therefore, the mindset for S has to change. Why S, the mindset is there? Because sometimes we feel that E and G are more riskier, they are more costlier, more dearer to corporate. But S, I feel, is the profit center. If you have more inclusivity, more diversity of opinion, more diversity of ethnicity, more diverse people there, and have fair wages, have a good CSR practices, it is going to give you a better profit center, it is going to give you a better leverage as a great advertising tool than anybody else. So I feel S is a very critical sector. Now coming back to what we do, we have, so Cube Highways is India's largest toll road operator. We have mostly, we are not covered under CSR, most of our companies are not covered under CSR because Section 135 may not be attracted to them. But many are still covered. But even those who are not covered, we have a community development program, a CDP, whereby we just do all these health centers we open, we have all these training centers, give tablets or laptops to the young students. Now the idea there is that, see, we operate toll roads, and our roads are at remote places. Most of the recruitment happens from the localites, from the vicinity villagers. Now if they're happy, if their family is happy, if they're happy that their kid got a laptop or a tablet, or they got a good health center, or they got a good education or some training, if they're happy, the family is happy, community is happy, we'll have happy workers. Happy worker means automatically they will do good and they will be that happy, you will have happy customers. Happy customers means your entire business is happy. So therefore that S part, inclusivity part is very critical. With this I rest right now. Thanks, Bhasin sir.
Thank you. I think you lead the road to ESG compliances. Heading, you see this as a general counsel of Cube Highways. Now it's very interesting to note from Mr. Pulin Kumar, who is the general counsel of Adidas, as to how he complies with, or his organization complies with, not only the Indian legal requirements and compliances, but also I think there must be some international, because you are an international organization, so there must be some standards set in place, you see, by your main corporations outside. You would like to know how you combine this challenge, you see.
Thank you, sir. If I talk haywire, don't blame it. It's like, I was nervous to share the dais with such a legendary person, Dr. Lalit Bhasin, and he is moderating the session, so don't blame it on me, and the blame should go to Dr. Bhasin. Yeah, see, a professional like me who would aspire to share the dais with such a legendary person, such a legendary living person amongst us. We are fortunate. I would rather love to hear him from the audience part of it, not sharing the dais, because the more we hear him, the more enriched we get here. So coming back to the topic again, since I am playing in the playing 11, I have to play my part of it also. So coming back to the topic, sir, as per our understanding or my understanding, it's not only ESG, but there are two more components to it, which is governance and the risk. So it's it makes a complete when we talk about GRC and ESG put combined and where the G is common in all the segments. And there are various elements under all the components here which makes a complete compliant industry where the emphasis is, I would only touch upon the social part of it because there are many things have been spoken already. I would not go into that. But the social part includes the mindset, as Dr. Mukul Sastry has also spoken about. It's a question of developing a mindset and developing a culture in the organization where we take into account of the various elements which helps us in various decision making in terms of the taking the business ahead. So now the question is not that only we are here to do business, earn money and go back. Now the question is that what we are getting here, what we are giving back into the society. And that comes from the understanding of the, sort of cultural understanding of the whole gamut of the business, where the social part is quite important and plays a very important role into it, and we need to take care of that also. Earlier, see, I would say that, unless and until we have some tone from the top and which goes to the regulations also, sir, there has to be some compelling circumstances to adopt a culture. So far as the business is concerned, because the primary goal of the business coming into any jurisdiction would be to whatever money has been pumped into, they should take it back also. Nobody would invest without having vision of the returns. So therefore, these are all voluntary contribution, and the pressure is right now is from the investors, the various stakeholders, how ESG we are compliant of. But the question is that, it used to be only in the one paragraph of the annual report, sir, that okay, we are ESG compliant and this is what it is. But now it is not limited to that one paragraph in the reports only. Now it is being seen and understood in the real context. So therefore, it is our own responsibility to really make it happen, and which includes the entire gamut of, like, if you talk about social, that's the labor law legislations, diversity, equity and inclusion, and employee engagement and experience. Nowadays we talk about mental health of the employee, that is also required. So all those aspects are being looked into from a holistic point of view. And diversity, inclusion and equity is the most important aspect where we are concentrating as you asked about the multinational culture which we are inculcating across the globe is the diversity, inclusion and equity. So these are the aspects which we look into, and we are not only limited to the one paragraph of the reports which we make for the board, but we are going beyond that, and that is the future. That is the future where we look at. CSR has come. That is one step which we have seen of late, that CSR has come into play, and where some pecuniary, some sort of pecuniary and penalty is there. So there is a fear psychosis, and then we talk about, sir, what to talk about rule of law, because the rule of law is this: unless and until something is made and which is coming out of the rule of law, certainly we are not going to have it a full optimization of the whole, responsibility which an organization is supposed to carry out. So therefore, it is all connected, and various elements put together would make a sustainable business growth, and that would also have the optimum utilization of the resources as well as the development and the progress of the conglomerate. So that is what I will pause here, sir. And
thank you very much. That was a brilliant point of view. The overview, not only with regard to ESG, but other responsibilities also of giving back to society, to the workers, to the people, and to the environment. You spoke about rule of law. Now, I don't understand this expression, particularly in the context of our Constitution. The preamble of our Constitution says that we, the people of India, give to ourselves security, that is justice, That is the first preamble. Justice, social, economic, political. The word justice is used. There is no expression like law. Law comes later on in the articles and all that. But what is being totally ignored is justice part of it. There is more emphasis on law making. At the drop of the hat, we bring in new laws. We bring in new regulators. We bring in more disputes. We bring in more disputes regarding interpretation of those laws. Emphasis should be, as I said earlier in the earlier session, on providing justice to the people. And that should be, instead of rule of law, it should be rule for justice. And justice, you see, for the common people. It is in that context that I feel the role of General Council and organizations like SOCHAM is very important and very significant. I'm very happy that SOCHAM has taken this initiative of organizing this event on different aspects. One aspect being, you see, the environment also. But the responsibility of compliances is on the General Council. I treat the role of General Council as very pivotal to any type of compliances, not just ESG. ESG is one part of it. I think they have to ensure compliances with hundreds of laws, and their teams have to constantly work on that. We have been telling, you see, the Bar Council of India, that please recognize the role of General Counsel, recognize them as good as the practicing lawyers in the courts. Why is there this requirement of keeping their license suspended when they are employed, you see, in an organization? They are employed as lawyers, and there should be no distinction, you see, between them. At least they should be allowed to appear in courts, you see, for and on behalf of the companies that they represent. We are having a dialogue with the Bar Council, but that is the role. Now, in that context, I want to ask one question to all three very eminent, esteemed panelists who are here. That one question is, how do you balance your role if there is a conflict between the business requirement and certain compliance, particularly in ESG or other compliances? How do you do your advisory? How do you do the balancing act, you see, as to the requirement by your board of directors and your commitment to stick to the rule of law, letter of law? So, very, very briefly, if you can, each one of you can tell us, because I know lunch is waiting. And if all of you are not, at least I am very particular about having my lunch on time.
Thank you, sir. And it's a very heartfelt question that you have actually asked, because you know, when we are law students, and I've had the privilege of also being in the law firm space for 10 years and then taking the switch to a corporate job. So I think it's inborn that, you know, the first thing as lawyers we are taught is, you know, you have to go by the book, you have to be honest to whoever, to your clients, to yourself. So I think, you know, the day I joined the organization and all my previous organizations, and which I tell my team every single day, is that our role is twofold. First of all, never forget that we are the conscious keepers of the organization. And we have to live by it. And I said, some days our job will be easy when business people go hand in hand with legal and compliance. And some days we will have to toe them in line when they are falling offline and not wanting to do compliance. But the important thing is that we are in-house counsels, and therefore our role is business legal partners. Business should happen, but definitely within the legal framework. So I think these are the two mottos that we drive our team with in our organization.
Sir, my take on your question is that, sir, you must have heard about the character in Mahabharata called Shikhandi. So whenever anything goes wrong, see, what was the role of the Shikhandi, you know? Shikhandi was to be portrayed on the front of Arjuna, where Dronacharya would not hit him because he had a he had a promise that he would not pick up the arsenals against the women. So Krishna suggested this is the only way to cut him out. So Shikhandi came in front of Arjuna and Dronacharya put his guns down and he was ultimately killed. Because if Dronacharya would have been there, Mahabharata could not have been conquered by Pandavas. So that's a role which we have been playing, sir, all along, because if something goes wrong, he is the Shikhandi. Ask him. But whenever we say that this is what it is to be done, then there will be a whole lot of Senate meeting, cost analysis, business propositions, disruption of the business and all that stuff. So we have also got the tricks of the day over working, in a corporate sector. So whenever we have some blocks like this, we suggest that why don't we take an opinion from Dr. Lalit Bhasin and push it through the board. And nobody would question that. Nobody would question that, I tell you, and this is the tip, you must take it, those who are younger. Whenever you have the blocks, stumbling block where you can't sail through, approach him. So take an opinion, put it across, and then come forward. This is only happening. You have raised the concern, sir, that we have no teeth to bite because we don't have a recognition. We are absolutely acting like a Shikhandi in an organization. We don't have any teeth to bite. We cannot plead, we cannot argue, we cannot appear in the court. So our role is just confined to the four corners of the wall. But yes, this has evolved quite a lot. I have started 35 years back my career. Now it is at the end of my career. I am seeing that we have come a long way. And the departments, the legal in-house councils are recognized, at least not by the world, but by the organization itself. And our partners, the practicing lawyers in this field. So they understand, and we have a big collaboration with each other and a bigger partnership with them so that we sail through and we achieve the objective and the end objective of the organization. So apart from that role, which I have again and again, I would love to portray myself, we have many other roles to play and we certainly take care of this.
Thank you very much. Over to you,
Yeah,
Mr.
so
Shastri.
I'll just sum it up. So, as rightly pointed out by Sandhya and Mr. Pulin Kumar, the role is that you have to balance between the business partnership and the conscience keeper. And just to conclude, and obviously Mr. Pulin Kumar has revealed the trick of the trade, that if you are stuck, then just go and take the umbrage and the great like Dr. Bhasin. But coming to just this question that whether we should be allowed as lawyers and whether there should be Amendment Advocate Act, I'm a staunch advocate that should be done because the role of GCs or the in-house counsel now has changed a lot. In fact, I would like to go one step ahead and say that all the vacancies which are there in tribunals, etc., should be filled up with these people also. The judicial members at many tribunals are still vacant, and I don't know why this. Yeah, step by step maybe, sir. But that is what the time has come. Because, say, I have spent time in infrastructure sector, so I understand that sector. Sandhya has spent time in pharmaceutical, she understands that sector. Mr. Pulin Kumar has spent time in that FMCG sector, he understands that business, that nuances pretty well, which I feel somehow only an advocate may not be in a position to bring out those perspectives at times. So there has to be a mix and match, and best of the talent should be utilized for best of the purposes. With this, I'd like to conclude. Thanks, Bhasin sir, and thanks, Pulin, and thanks, Sandhya.
So thanks a lot. I thank the eminent panelists. I don't think there is time now for more active consideration of the topic, but you have touched upon the core of the subject in your presentations and your address and your comments. Therefore, we wind up this session on this pleasant note that we, the General Counsel, they deserve a better understanding, you see, from the top bosses in the corporates, as also by our regulator, that is the Bar Council of India. We as external lawyers have a very cordial relationship, and we recognize the eminence and the importance of their knowledge, because without their support you can't do anything, whether in advisory work or even in the courts. In the courts, they instruct, you see, as to what are the issues. Because a lawyer has to be familiarized not just with the issue, but broadly with the overall work practices, the culture, and the type of activity that is going on. So it has been a brilliant learning experience for me as chairing this from the very, very eminent General Counsel. So with that, we end the note, and I thank the SOCHM for organizing this. Thanks a lot.
Thank you very much for a very knowledgeable session. Kindly keep the applause going. Thank you so very much for sparing your valuable time and joining us for this conclave. Please step forward for a group photograph. Or maybe you can stand here only. It's fine. Then it's fine, sir. Thank you very much. Ladies and gentlemen, we'll now pause for 1 hour lunch break. The lunch is organized towards the end of the hall. You may enjoy the same and kindly reassemble in time for the rest of the conclave and the grand award ceremony. Thank you so much. Enjoy your lunch. Please be seated. As our chief guest will be joining us in any moment from now.
एक ही काम में हमारी सरकार ने एस्टिमेट कॉस्ट से 5,000 करोड़ रुपए की बचत की और ये करके दिखाया.
We at ASSOCHAM are immensely grateful for the recognition given to us by the Honorable Union Minister Shri Nitin Gadkari ji, both in the public forums and in the Lok Sabha, the Indian Parliament.
Let's welcome him with a standing ovation and a thunderous round of applause. Our chief guest, Shri Arjun Ram Meghwalji, Honorable Minister of State, Ministry of Law and Justice, Independent Charge, Minister of State, Ministry of Parliamentary Affairs, and Minister of State, Ministry of Culture, Government of India. Kindly keep the applause going. We request a roaring round of applause, ladies and gentlemen. A very warm and hearty welcome to our chief guest, Honorable Minister Shri Arjun Ram Meghwalji. We request our Honorable Minister to please be seated on the dais. Joining him are Shri Suresh Chandra, Information Commissioner, Central Information Commission, Government of India. Former Secretary, Ministry of Law, Justice, Government of India. Mr. Deepak Sood, Secretary General ASSOCHAM, Ms. Preeti Malhotra, Mr. Akshat Khaitan, Mr. Rajinder Kumar. All have joined in for the lamp lighting ceremony.
शत्रुबुद्धि विनाशाय दीपज्योतिर्नमोस्तुते दीपज्योतिर्नमोस्तुते.
A round of applause, ladies and gentlemen, as our chief guest lights the ceremonial lamp.
दीपज्योतिर्जनार्दनः दीपज्योतिर्परब्रह्म दीपज्योतिर्जनार्दनः दीपो हरतु मे पापम् सत्यादीप नमोस्तुते. ओ दीप ब्रह्मरूपस्त्वं ज्योतिषां प्रभुरव्ययः. ओ दीप ब्रह्मरूपस्त्वं ज्योतिषां प्रभुरव्ययः. आरोग्यं देहि पुत्रांश्च मतिं स्वच्छां हि मे सदा. रवेरस्तं समारभ्य यावत् सूर्योदयो भवेत्. रवेरस्तं समारभ्य यावत् सूर्योदयो भवेत्. यस्य तिष्ठेत् गृहे दीपः तस्य नास्ति दरिद्रता. शुभं कुरु त्वं कल्याणम्.
Let's welcome our esteemed dignitaries on the dais, ladies and gentlemen. Our chief guest, Shri Arjun Ram Meghwalji, Honorable Minister of State, Ministry of Law and Justice, Minister of State, Ministry of Parliamentary Affairs, Minister of State, Ministry of Culture and Government of India. Ms. Preeti Malhotra, Chairman, National Council for Corporate Affairs, Company Law and Corporate Governance, and Chairman, Smart Bharat Group. Mr. Akshat Khaitan, Founder, AEU Corporate Advisory and Legal Services, representing the event partner. Mr. Rajinder Kumar, Managing Partner, Kumar Law Associate, being Evaluation Partner for National Legal Excellence Award. Are we all applauding, ladies and gentlemen? Let's again welcome our distinguished dignitaries. Thank you very much. माननीय मंत्री, आपका बहुत बहुत आमंत्रित करते हैं. Thank you so much for joining us. And now, ladies and gentlemen, without any further ado, please join me in welcoming a dynamic leader and chairperson of ASSOCHAM, National Council for Corporate Affairs, Company Law, Corporate Governance, as well as chairman of Smart Bharat Group, Ms. Preeti Malhotra to render the welcome as well as the opening address.
Thank you.
We once again welcome our honorable chief guest. आज आप यहाँ समय निकाल कर आए हैं, आपका बहुत बहुत शुक्रिया, धन्यवाद. Over to Ms. Preeti Malhotra.
Thank you so much. A very good afternoon to all. Honorable Chief Guest for today, Shri Arjun Ram Meghwal ji, the Minister of State, Ministry of Law and Justice, Independent Charge, Minister of State, Ministry of Parliamentary Affairs, and Minister of State, Ministry of Culture, Government of India. Sir, we are so thankful and so grateful for you having been here. He's been so busy in the morning, with multiple meetings, important meetings, and he especially left that and come for us for half an hour today. Thank you, sir. Really grateful and really appreciate. Mr. Suresh Chandra, Information Commissioner of India, Mr. Rajendra Kumar, the Managing Partner, Kumar Law Associates, Mr. Akshat Khaitan, Founder, EU Corporate Advisory and Legal Services, other dignitaries of the dais, distinguished legal luminaries, eminent guests, I really warmly welcome you to the National Conclave, National Legal Conclave, and I thank all the speakers and panelists here for the excellent panel discussions that preceded this function, the award function. Sir, ASSOCHAM has been contributing from the forefront for policy changes that aligns to the mandates of almost all ministries and regulators under the Government of India. We work in sync with the government and with international best practices. Legal and regulatory affairs are an important subject for businesses and industry, sir, and ASSOCHAM has been playing a very critical role. We've been making very impactful submissions, and the most recently being the leading participatory role in the process of enactment for a strong protection of trade secrets and economic espionage legislation in India with the Law Commission of India. So, ASSOCHAM's Bharat Legal Conclave is a yearly flagship event for stakeholders to amalgamate, discuss, debate, and contribute towards favorably amending and impacting the futuristic legal and regulatory reforms in India. And the conclave today morning has deliberated on a range of important subjects. And in conjunction to this conclave, we sincerely believe that appreciation and recognition are powerful tools and for motivation, and which have a In conjunction to the conclave, we sincerely believe that appreciation and recognition are powerful tools for motivation and trust building among stakeholders. And therefore, we've driven this award process. In fact, we have a legacy of 15 years of giving the Responsible Organization Excellence Awards, and taking cue from that, this is the first time we've instituted the Legal Excellence Awards. And we are so grateful, sir, through your hands, we'll be bestowing the first of these awards this year. So with the spirit of bestowing these awards, so the participants are evaluated on various broad-based parameters. There's a question setting. The process started right since December 22. And we have an external evaluation partner. Mr. Rajendra Kumar is here. So just to ensure that there's no conflict of interest, there's no bias, the evaluation partner, along with other partners, does the entire evaluation process, and then the ranking is placed before a jury. So we had a very, very eminent jury, which is headed by the former Chief Justice of India, Justice Deepak Mishra. And I thank Justice Deepak Mishra for chairing the jury and all the other jury members. Really thank them from the bottom of our heart. So the process of evaluation, as I mentioned, was done by Mr. Rajendra Kumar. He'll briefly mention that to you in the next 2 minutes. I'm pleased to mention that we've got such an overwhelming response for these award functions that people are preparing themselves for 2024 awards right away. We'll be bestowing the awards through the hands of the Honorable Minister. I'm not taking much time because the Minister is here just for about 20-25 minutes. So thank you again for being here. And let's again give him a warm, heartily welcome.
Thank you very much, ma'am. Our next speaker is founder of AU Corporate Advisory and Legal Services, representing here as the event partner organization. Let's hear from Mr. Akshat Khaitan. Sir.
respected Shri Arjun Ram Meghwal ji, Shri Suresh Chandra ji, Ms. Preeti Malhotra, ladies and gentlemen, esteemed colleagues and distinguished guests. The foundation of a thriving economy lies in the strength of its legal system. No nation can achieve sustainable economic growth without justice, transparency, and the rule of law. It is with great honor that I stand before you today to be part of this inaugural session in the vital congregation of minds, the Bharat Legal Conclave. In an era where the legal landscape continuously evolves at the precipice of technological advancements and human rights, awareness gatherings such as these embody the crucibles of innovation. As we dwell into the intricate realm of law, from corporate intricacies to the nuances of civil liberties, may we remain anchored to the ethos of justice. In parallel, the role of our present government under the dynamic leadership of our visionary Prime Minister, Shri Narendra Bhai Modi, in shaping this corporate landscape cannot be understated. Through policy reforms, incentive-based schemes and digitalization drives, the government has shown a commitment to transforming India into a global business powerhouse. A country's economic success is not only about resource availability, but equally about the presence of a robust legal system that safeguards trust, investment, and fairness for all. I confine my speech to this very limited words and thank you, and I hope that this conclave will take us all and lead into a vibrant, constructive force capable of elevating the whole aspect of our country's economic development into a new realm of growth, prosperity, and enlightenment. Thank you so much.
Thank you very much, and I now invite Shri Suresh Chandra ji to address the august gathering. Please welcome him.
Honorable Minister for Law and Justice, respected Shri Arjun Ram Meghwal ji, Ms. Preeti Malhotra, Chairperson SOCHM, Mr. Rajendra Kumar, Mr. Akshay Khetan, and all the dignitaries sitting on the dais, ladies and gentlemen. It is my proud privilege to be amongst you gathering here on the occasion of Bharat Legal Conclave and National Legal Excellence Award Function 2023. The theme of today's conclave include innovation and empowering India, merger and acquisitions, transforming disputes into economic opportunities. It's a new subject which is very new for me. You are drawing opportunities out of the disputes, and that is true. How we can make India as a hub of arbitration, alternative dispute resolution, if we are able to enhance our standards. Sir, the preamble of the Constitution emphasizes the unity of nation, and it proceeds further to define the objectives of the Indian Republic. Article 38 and Article 39 mandate inter alia that the state shall strive to promote the welfare of the people by securing and protecting as effectively as it may that the ownership and control of the material resources of community are so distributed as best serve the common good, and that operation of the economic system does not result in concentration of wealth and means of production to the common detriment. I am delighted to share through this Bharat Conclave, the SOCHM has partnered with Legal Fraternity, which represents very strong community of legal practitioners and professionals of over 15 lakh. The bar is equally responsible for regulating legal education, for regulating access to justice, and also evolution of law, its implementation and resolution of conflicts. The Indian legal system personnel have more onus as one of the Advocates Act. As under the Advocates Act, the power to implement legal education, legal profession have been assigned to the Bar Council of India. It further gives me immense pleasure that those who have contributed remarkably to the legal profession, they are being awarded. I congratulate all the awardees and wish and hope that this recognition would encourage others to join the movement of doing good to the people. Sir, because Law Minister is here and I shall be failing in my duties if I do not bring out certain important challenges with the legal fraternity and the people, especially the conflicts are facing as on today. Sir, we have over 5 crore cases pending in the courts. When we, because I have almost 40 years of experience in the legal field, wherein most of the period I have spent in the law ministry. We started legal reforms from the CPC amendment to the Negotiable Instruments Act, and again constituting the fast track courts, and thereafter, sir, we started amending the Arbitration Act as well as the Constitution of Commercial Courts. Sir, if you remember, in 2000, the pendency was only 2 crore cases. Nowadays, it is increasing in spite of our efforts, the government's efforts to have multiple tribunals. Sir, in 2015, I had recommended to the government of rationalization and merger of some of the tribunals. We brought down these tribunals from 37 to 17 only. Apart from that, sir, we started one proposal that was for constituting an integrated legal division in the law ministry, one international treaty division as well. Why I am highlighting this, sir? Because if you are bringing good people and taking all administrative decisions which are enforceable or infallible, then the disputes and the conflict will be very less. If we are able to make the laws simple and unambiguous, then the conflict will also be coming down. We have rationalized, we have brought down a lot of obsolete laws. So all this process is going on. But somewhere, sir, we have been missing the bus, and somewhere that tribunalization is multiplying the organizations, and lot of variable decisions are coming. There is no uniformity. That is what I want to point out. If your lordship or if the honorable minister can address these issues, I think that will be a great help to the legal profession. Sir, just to conclude, the minister is short of time. I would like to only highlight few points under the Constitution, Article 53, Article 77, and Article 309. I would like to draw your attention. 53 says that unity of command, and under the unity of command, all executive functions vest in the president. Earlier, there used to be decisions taken in the ministries which were infallible. But nowadays, sir, we are separating the development from the regulation. We are conferring the regulations to certain bodies which are outside the government, and sometimes they are becoming unruly horse. If the people manning these institutions are very good, then definitely they are going to contribute a lot. If the appointment in such high-level commissions or adjudicatory bodies are not very good, then you will face these situations wherein the Supreme Court is passing the orders and calling the people for explaining their conduct. This is happening. I will say that, sir, 77 I am saying, sir, because the contribution of the Ministry of Law from the time the legislation is made out, the implementation of the laws, and also conflict resolution is like, जैसे हम कहते हैं ना कि एक रूह की तरह होता है किसी में, तो the contribution is just like a golden thread which runs throughout the implementation of the laws. If the laws are good, implementation and conflict resolution is there, then we can achieve the objective of becoming the developed nation by 2047. That is our objective, and with these objectives and with aspirations, the young lawyers, those who have contributed in the legal profession, I congratulate them all, and with these words I conclude. Thank you very much for inviting me. Thank you, sir.
Thank you very much, sir. Ladies and gentlemen, please welcome our evaluation partner, Mr. Rajendra Kumar, Managing Partner of Kumar Law Associates.
Honorable Minister, Shri Arjun Rampalji, other dignitaries on the dais, distinguished professionals, ladies and gentlemen, very good afternoon to everyone. Role played by the legal professionals in India and their contribution to the economy, law and justice is significant. Towards this endeavor, SHM team led by Mr. Santosh Parashar were instrumental in pioneering the Legal Excellence Awards in different categories to recognize the excellent performance by legal professionals so that they get motivated, their productivity gets enhanced, and they are encouraged to achieve better than the best outcomes. Kumar Law Associates had the privilege to assist as an objective and independent evaluation partner in this exercise. I will now briefly touch upon the process that was followed. So there are awards in the different categories: the Law Firm of the Year, Individual Practitioners, Corporate In-House Teams, Academia, Lifetime Achievement Award, and Special Jury Recognitions. The process which was followed was in different stages: the framework setting, that is defining the eligibility and evaluation criteria. Then for evaluation 1 stage about the eligibility, evaluation 2 stage about the parameters for deciding the performance, and then we had the jury meeting which decided, and the award ceremony which is taking place today. The jury was led by none else than Mr. Honorable Justice Deepak Mishra, and other members were Mr. Suresh Chandra, Ms. Preeti Malhotra, Mr. Hemant Sahai, Dr. Ranbir Singh, Mr. Mohit Mathur, Senior Advocate, Mr. Sumit Malik, and Dr. Sanjeev Gemawat. We will shortly witness the award ceremony. Thank you.
Thank you very much, sir. Ladies and gentlemen, it is indeed an honor to invite on the dais our chief guest, Honorable Minister Shri Arjun Ram Meghwal ji. His unwavering commitment to public service and his dedication to the principle of justice makes him a true beacon. Let's welcome him with a thunderous round of applause.
एसोचैम द्वारा आयोजित ये कार्यक्रम, और कार्यक्रम का नाम भी बहुत अच्छा दिया आपने, भारत लीगल कॉन्क्लेव 2023, और इस अवसर पर उपस्थित हमारे माननीय सुरेश चंद्रा जी, एक्टिंग चीफ इंफॉर्मेशन कमिश्नर, सेंट्रल इंफॉर्मेशन कमीशन में गवर्नमेंट ऑफ इंडिया, और हमारे लॉ डिपार्टमेंट में भी ये सेक्रेटरी रहे काफ़ी अभी बताया 40 साल का अनुभव, आपके अनुभव का लाभ लेंगे सब बीच में कभी। हमारे प्रीति मल्होत्रा जी, इनके कई फंक्शनों में मुझे जाना पड़ता है, क्योंकि ये कई बार जब मैं यहाँ दिल्ली में होता हूँ फ़ोन करके कह देते हैं हमारा फंक्शन है, आपको आना है। ऐसा ही आज का जो चेयरपर्सन है एसोचैम के, हमारे राजेंद्र कुमार जी को चेयरपर्सन्स हैं, और हमारे विजय सचदेवा जी, अक्षत खेतान जी, और इस सभागार में उपस्थित सभी लीगल फ्रेटर्निटी के सभी हमारे वकील साहिबान, कुछ चार्टेड अकाउंटेंट हैं, कुछ सीएस हैं, लेकिन काम ऐसा ही है जिनका लीगल माइंड चलता है। लेकिन दो मुझे दिखे जो स्पिरिचुअल माइंड के आदमी आए, ओम शांति। तो आपका भी काम अच्छा है। आप कुछ कोई ज्ञान देने वाले हो क्या? नहीं, जरूरी है ज्ञान। देखिए, मैं अभी देख रहा था तो यहाँ मातृशक्ति भी काफी बड़ी संख्या में है। मेरे ख्याल में काफी एडवोकेट, इधर भी देख रहा था, पीछे भी देख रहा था, तो अच्छी संख्या में। तो उनके लिए तो ताली बजा दो भाई, इतनी बड़ी संख्या में आए। समय नहीं मिलता है, घर में कई बार काम हो जाता है, कई बार चीजें आ जाती है, लेकिन इतनी बड़ी संख्या में मातृशक्ति, क्योंकि हमने अभी पार्लियामेंट में एक बिल पास किया, नारी शक्ति वंदन, उसके लिए भी धन्यवाद दे दो आप मोदी जी को, बड़ा काम किया। और प्रीति जी भी हमारे नारी शक्ति वंदन का ही पार्ट है, तो इनके लिए भी आप ताली बजा सकते हो भाई। मुझे ज्यादा नहीं बोलना है, क्योंकि 2-3 इशू सुरेश चंद्रा जी ने रेज किए। देखिए, मैं खुद चाहता हूं, मैं जब लॉ मिनिस्टर बना था तो मेरा पहला स्टेटमेंट था कि हमें पेंडेंसी कम करनी है। हमने उपाय बहुत किए, ऐसा नहीं है, लोक अदालत से लेकर के, फास्ट ट्रैक कोर्ट से लेकर के, हमारे मोबाइल, हमारे कोर्ट से लेकर के, कई तरह की टेक्नोलॉजी का यूज भी किया, लेकिन मुकदमे बढ़ते गए। उसके कारण कुछ भी रहे होंगे, हम जब कभी बैठेंगे तो कानूनों में जाना पड़ेगा। मुकदमा बढ़ता है तब लड़ाई होती है। तो ओम शांति के जब हम जाते हैं तो ये कहते हैं कि बॉडी, माइंड, इंटेलेक्ट और सोल एक पेज पे रहना चाहिए। और जैसे भी किसी आदमी का या किसी पुरुष और महिला, सब उसी को ह्यूमन बीइंग ही कहते हैं, वी कैन कॉल इट द ह्यूमन बीइंग। उसका अगर बॉडी, माइंड, इंटेलेक्ट और सोल एक पेज पे रहेंगे तो मुझे लगता है झगड़े भी कम होंगे ना। आपको क्या लगता है? आप एक लेक्चर दे देना भी आप। और जब एक पेज पे रहेंगे तो हमारा क्रोध भी कम रहेगा, हमारे मन में भी शांति रहेगी। और हमारी भारत की परंपरा है, आपने तो नाम भी अच्छा रखा है, भारत लीगल कॉन्क्लेव। हम आजादी के अमृत महोत्सव में चल रहे हैं, 75 साल हम कैसे चले इसका विश्लेषण करने का समय है, लेकिन आगे 25 साल कैसे चलेंगे, जब हम 2047 में हम आजादी का 100वां हम जश्न मनाएंगे तो हम विकसित भारत होंगे। इसका रोड मैप भी तैयार करना है, यह भी एक विषय होना चाहिए हमारा। अब आप देखिए कि आज जिनको अवार्ड मिल रहा है, हमारी शुभकामनाएं, लेकिन अभी जूरी का भी जिक्र आया, इसमें ईमानदारी बरती गई होगी, लेकिन कोई कमी हो तो जिनको नहीं मिला है अगली बार दे देना प्रीति जी आप। हाँ, परेशान होने की जरूरत नहीं है, लेकिन काम अच्छा करेंगे तो अवार्ड कहीं ना कहीं, ये भी एक प्रोत्साहन है, इंसेंटिव है। जो अच्छा काम करते हैं सोसाइटी में, कोई इसको आगे आता है, अवार्ड देता है, इट इज ऑल्सो जस्टिस। और जो काम नहीं करता उसको दंड देने का प्रावधान भी है। हम तो इस समय, आपने नाम भारत रखा है, हम कई चीजें कर रहे हैं जी। आईपीसी को हम सुधार रहे हैं, सीआरपीसी कभी किसी ने हाथ ही नहीं लगाया। इंडियन एविडेंस एक्ट 1872 का किसी ने सोचा ही नहीं इसमें क्या नाम लिखा हुआ है भाई। इसमें कई ऐसे नाम हैं जो हमारे आजादी से मेल नहीं खाते हैं, लेकिन है नाम, किसी में कल्पना ही नहीं की। प्रधानमंत्री मोदी जी ने इसको समग्रता से सोचा आईपीसी, सीआरपीसी, एविडेंस एक्ट में अमेंडमेंट की बात भी सोची, एक बिल भी हमने पेश किया है हमारे गृह मंत्री जी ने, और जल्दी इस पे काम भी हो रहा है। तो ऐसे कुछ काम नए बराबर अभी जैसे मीडिएशन बिल पास किया। अब मीडिएशन बिल में हम भारत जो है वो आर्बिट्रेशन का हब क्यों नहीं बन सकता जी? अब कभी हम देखते हैं सिंगापुर, हांगकांग या कहीं लंदन या कहीं जज भी हमारा, दोनों पार्टियां लड़ने वाली भी हमारी और बहस करने वाले वकील भी हमारे, वहां जाकर के आर्बिट्रेशन करते हैं। तो हम इंडिया में क्यों नहीं कर ले भाई आर्बिट्रेशन का काम? इस दिशा में सोचना पड़ेगा। हम आर्बिट्रेशन के हब भी बन सकते हैं। मीडिएशन का काम हमने, मीडिएशन एक्ट हमने अभी इसलिए पास किया है, कॉमर्शियल कोर्ट का आपने जिक्र किया, ये सब सुधार हैं जी, क्योंकि इसमें टेक्निकल एक्सपर्टीज भी चाहिए। लेकिन फिर मैं कह रहा हूं कि आपका काम ज्यादा जरूरी है। एक उदाहरण मुझे याद आ गया, एक उभय भारती करके एक महिला विदुषी थी। जब शंकराचार्य वहां से रवाना हुए केरला से, और बहस करो मेरे से, शास्त्रार्थ करो, कौन जीत सकता है, तो एक चैलेंज आया मंडन मिश्र का। मंडन मिश्र ने कहा मेरे से बहस करो। ये डिबेट ही है, जैसे आप वकील भी बहस करते हैं चैम्बर में। निर्णय होना चाहिए, लेकिन वो जस्टिस की ओर जाने वाला होना चाहिए। निर्णय तो होता है, लेकिन जब वो जस्टिस की ओर नहीं जाता तो अपील होती है, अगेन पेंडेंसी। लेकिन निर्णय जब उसको लगता है कि जस्टिस हो गया तो फिर कोई अपील भी नहीं होती। तो ऐसे ही मंडन मिश्र ने चैलेंज किया, पहुंच गए शंकराचार्य जी। लेकिन हुआ क्या कि जूरी कौन, जैसे भी आपने जिक्र किया कि निर्णय कौन करेगा, जीता कौन? तो 3 दिन 4 दिन तक बहस चलती रही। उभय भारती जूरी में आ गई। मंडन मिश्र की पत्नी थी, सब कोई भाई भतीजावाद नहीं था हमारे सिस्टम में, वो उनकी पत्नी थी। लेकिन वो तो बहस ऐसी थी कि कोई निर्णय नहीं कर पा रही थी। तो बराबर है, तराजू पे तोलती थी जब उभय भारती, तो देखती थी मंडन मिश्र भी बराबर है, हमारे पति भी, और शंकराचार्य भी बराबर है। निर्णय किसके पक्ष में करें? अब अचानक कहीं बाहर जाना पड़ गया उभय भारती को, और कहा आप तो बहस करते रहो। तो उन्होंने कहा हम कैसे बहस करते रहेंगे, निर्णय कौन करे? बोला निर्णय हम करेंगे, आप बहस करते रहो, पता कर लेंगे। तो क्या करके गई देखिए, उस जमाने में भी जंगल में गई, 2 मालाएं बनाई नेचुरल फूल की, और दोनों को पहना के गई। एक अपने पतिदेव को पहना दिया और एक शंकराचार्य जी को पहना दिया। बोला बहस करते रहना, मुझे 4-5 घंटे लगेंगे, 4-5 प्रेयर लगेंगे, जो भी समय था उस समय। लेट आई तो बहस चल रही थी। उन्होंने कहा करीब बहस आपकी समाप्ति की ओर है। बोला हाँ, करीब करीब हमारे सभी जितने भी हमारे शास्त्र थे सब में बहस होगी हमारी। बोला अब निर्णय, कुछ तो सुने आपने, कुछ आप बाहर थे? बोला नहीं, मैंने नहीं सुना है, तो भी मैं निर्णय करने की स्थिति हूं। कितना शानदार निर्णय दिया उभय भारती ने। जो माला वो पहना के गई थी, अपने पतिदेव को गुस्सा आ गया, इसलिए माला मुरझा गई, और शंकराचार्य जी को गुस्सा नहीं आया, इसलिए माला ऐसी थी, अपने पति को हरवा दिया और कहा तुम हार गए और शंकराचार्य जीत गए। ऐसी महिला विदुषी थी भाई। इसके लिए तो ताली बजा दो भाई, क्या है इसमें? आनंद आना चाहिए ना, क्या शानदार निर्णय दिया। उसने पति ने पूछा भी कि आप तो यहां थे ही नहीं, जब आप गए थे छोड़ करके, तब तो हम बराबर थे, आप कैसे निर्णय कर रहे हो शंकराचार्य जी पक्ष में कि मैं 2 माला पहना के गई थी पतिदेव, आपको गुस्सा आ गया इसलिए माला मुरझा गई, और शंकराचार्य जी गुस्सा नहीं आया इसलिए माला वैसी की वैसी है। तो ऐसा गुस्सा नहीं आना चाहिए, ऐसा भी आप एक उपदेश देना भी, तब जाके लीगल फ्रेटर्निटी में थोड़ा और 4 चांद लगेंगे। आपने मुझे बुलाया, जिनको अवार्ड मिला उनको शुभकामनाएं, जिनको नहीं मिला अगली बार तैयारी करना भाई। असफलता ये सिद्ध करती है कि सफलता के लिए पूर्ण मनोयोग से प्रयास नहीं किया, ट्राई, फिर सफलता मिलेगी जी। और शॉर्टकट नहीं है जी सफलता में, ध्यान रखना। मुझे जानता हूं काफी लंबे समय से प्रीति जी को, इन्होंने निर्णय अच्छा ही किया होगा, जूरी में भी अच्छे ही लोग रहे होंगे मेरे ख्याल में। बहुत बहुत शुभकामनाएं, बहुत बहुत धन्यवाद। मुझे सुख की दूसरी मीटिंग में जाना है, इधर से मैसेज आ रहा है, इसलिए बहुत बहुत बधाई और शुभकामनाएं। धन्यवाद आपको।
धन्यवाद माननीय, आपके प्रेरणात्मक शब्दों के लिए आपका हार्दिक धन्यवाद। Well, it's time to honor excellence. Ladies and gentlemen, the heart of the gathering lies in acknowledging the brilliance and dedication of individuals who have made exemplary contribution. It's time to announce the ASSOCHAM National Legal Excellence Awards 2023. I request our Chief Guest, Honorable Minister Shri Arjun Ram Meghwalji, special guest along with leadership from ASSOCHAM, to please step forward for the presentation of awards. Ladies and gentlemen, the first category is the Law Firm of the Year. And the winner is Lex Orbis Consulting Private Limited, Law Firm of the Year in the IPR category. Lex Orbis Consulting Private Limited. We need a louder round of applause. We've just started the much-awaited National Legal Excellence Awards. Many congratulations. The Law Firm of the Year in Competition Law goes to Try Legal. The winner of Law Firm of the Year in Competition Law category is Try Legal. Kindly keep the applause going. Many congratulations to the Golden Awardees. Law Firm of the Year in Taxation, and the winner is S&A Law Offices. Law Firm of the Year in Taxation, and the winner is S&A Law Offices. We once again request the winner of the Law Firm of the Year in IPR category, Lex Orbis, to please join us. Once again, a thunderous round of applause, ladies and gentlemen. And now, ladies and gentlemen, the Law Firm of the Year in Taxation, the winner is S&A Law Offices. S&A Law Offices. And now, ladies and gentlemen, the Law Firm of the Year in Taxation. The notable law firm is BMR Legal Advocates. In taxation category, the notable law firm is BMR Legal Advocates. Up next is the Law Firm of the Year in Financial Regulatory, and the award goes to AK and Partners. The winner of the Law Firm of the Year in Financial Regulatory is AK and Partners. A roaring round of applause, ladies and gentlemen, for the winners who are coming on the stage. Law Firm of the Year in IBC category, and the winner is S&A Law Offices. In IBC category. Law Firm of the Year in Litigation, and the winner is MCO Legals. MCO Legals, Law Firm of the Year in Litigation. Please quickly make your way to the stage. We can't wait to felicitate you. Kindly keep the applause going, ladies and gentlemen. Law Firm of the Year in Litigation, the notable goes to S&A Law Offices. Notable S&A Law Offices, double congratulations. There is one more notable in this category, RRG and Associates. In litigation category, there is one more notable, RRG and Associates. Law Firm of the Year in ADR, and the winner is S&A Law Offices. Law Firm of the Year in Real Estate, and the winner is Integrat Law Offices LLP. Please give it up for Integrate Law Offices, ladies and gentlemen. In Real Estate category, Law Firm of the Year. Many, many congratulations. Law Firm of the Year in Insurance, and the winner is RNS Associates. In Insurance category, RNS Associates. Requesting the winners to quickly make their way to the stage. Law Firm of the Year in Insurance, RNS Associates. Are we all applauding, celebrating? Law Firm of the Year in Energy, and the winner is Alaya Legal Solutions Private Limited. In Energy category. And for this we need an energetic round of applause for the winner, Alaya Legal Solutions Private Limited. Our next category is individual practitioners, corporate in-house and law firms. First, I will announce the awardees of the category individual practitioners, corporate in-house. The General Counsel of the Year, and the winner is Mr. Vineet Vij from Tech Mahindra. Mr. Vineet Vij from Tech Mahindra. The notable General Counsel of the Year is Ms. Sandhya Tolat from Aarti Industries Limited. Please give it up for Ms. Sandhya Tolat, Aarti Industries Limited. We have one more notable in this category. That's Mr. Manish Kharbanda from Jindal Steel and Power Limited. The notable in General Counsel of the Year category, Mr. Manish Kharbanda. Moving on to the Women General Counsel of the Year, and the winner is Ms. Sandhya Tolat, once again from Aarti Industries Limited. Please give it up for the lady on stage, Ms. Sandhya Tolat, the winner of the Women General Counsel of the Year. Well, the notable in this category is Ms. Shilpa Malhotra, National Payments Corporation of India. Ms. Shilpa Malhotra is the notable in the category Women General Counsel of the Year. Ms. Shilpa Malhotra. We have two more notables in this category. The next is Ms. Smitha Chandrasekharaya from Harman International India Private Limited. Ms. Smitha Chandrasekharaya. She is receiving on behalf of Mr. Manish Kharbanda from Jindal Steels and Rubber Limited. And now I request Ms. Smitha Chandrasekharaya to please be on stage. The lady on stage is receiving the award on behalf of Mr. Manish Kharbanda from Jindal Steel and Power Limited for the General Counsel of the Year. And now again we move on to the category of the Women General Counsel of the Year, and the notable is Ms. Smitha Chandrasekharaya from Harman International India Private Limited. The notable is Ms. Shalini Kulshrestha from Dentsu Aegis Network India Private Limited. Ms. Shalini Kulshrestha. Our next category is recognized law practitioners, age under 30, and the winner is Ms. Ekta Gupta from Jindal Steel and Power Limited. Please give it up for Ms. Ekta Gupta from Jindal Steel and Power Limited. Our next category is recognized law practitioners age under 40, And the award goes to Mr. Srijit Mukherjee from HCL Tech. Kindly keep the applause going. Up next is Ms. Sandhya Tolat from Aarti Industries Limited. Recognized law practitioner, age under 40, Ms. Sandhya Tolat. Our next awardee is Mr. Saurabh Dubey from Statecraft India Private Limited. Please put your hands together for Mr. Dubey, ladies and gentlemen. Our next awardee in this category is Ms. Satabdi Mohanty from Thermo Fisher Scientific India. And now, ladies and gentlemen, I'll announce the awardees of the category Law Firm Partner of the Year. And the winner is Mr. Siddharth Srivastava from Khaitan and Company. The notable in this category is Mr. Amit Meharia from NCO Legals, Meharia and Company. The notable for the Partner of the Year is Mr. Amit Meharia. If Mr. Bhupendra Malik is in the hall, so kindly come near the stage. Please give it up for Mr. Amit. The other notable in this category is Advocate Rajesh Rai from RR Legal Partners LLP. Our next category is a Woman Lawyer of the Year, and the winner is Ms. Rupinder Malik from JSA. Ms. Rupinder Malik. Moving forward to the next winner, Ms. Nisha Kaur from Tri-Legal. Ms. Nisha Kaur from Tri-Legal, the Woman Lawyer of the Year. The notable in this category is Ms. Kavita Vijay from IC Universal Legal. Ms. Kavita Vijay. Moving forward to the next notable, that is Ms. Ranjana Roy Gawai from RRG and Associates. The notable in the Woman Lawyer of the Year category, Ms. Ranjana Roy Gawai, RRG and Associates. Moving forward to our next category, which is the Dispute Resolution Lawyer of the Year. And the winner is Mr. Biswajit Dubey from Cyril Amarchand Mangaldas. And the notable in this category is Ms. Gunita Pahava, S&A Law Offices, the Dispute Resolution Lawyer of the Year. Our next category is the Recognized Law Practitioner, age under 40, and the first winner is Mr. Karthik Jain from JSA. Can we have a louder round of applause, ladies and gentlemen? Ms. Kritika Krishnamurthy from AK and Partners, the recognized law practitioners. Kindly keep the applause going. Mr. Abhinav Kumar from Cyril Amarchand Mangaldas. Ms. Minal Madan from SLP Law Firm. Ms. Meenal Madan. Many congratulations. Dr. Vijay Avana from Central Juris. Dr. Vijay. We need a thunderous round of applause, ladies and gentlemen, a louder one. It feels great, to hear those applause when you're on stage. Up next is Advocate Mr. Manik Ahluwalia. Recognized law practitioners, age under 40. Advocate Mr. Manik Ahluwalia. Up next, Ms. Shraddha Singh Chauhan, Anand and Anand Advocates. Ms. Shraddha Singh Chauhan. Our next award is Ms. Hena Vadhera from Khaitan and Company. Ms. Hena Vadhera from Khaitan and Company, the recognized law practitioner, age under 40. Ms. Hena. Our next category is for in-house legal compliance team of the year, and the winner is Niva Bhupa Health Insurance Company Limited. Niva Bhupa Health Insurance Company Limited, the representatives to be please be on stage. Please give it up, ladies and gentlemen. Please put your hands together for Niva Bhupa Health Insurance. The notable in this category is DCM Shriram Limited. DCM Shriram Limited. The next is in-house legal team of the year, Defense and Aerospace, and the winner is Thales Group. The winner is Thales Group. We have special prizes for the front row as they are the ones who are applauding. In-house legal team of the year, Energy and Resources, winner is HPCL. Energy and Resources, HPCL. In-house legal team of the year, Innovation and Technology, the winner is Godrej and Boys Manufacturing Company Limited. Godrej, please give it up for Godrej. In-house legal team of the year, FMCG, and the winner is Marico India Limited. Please give it up for Marico India Limited, ladies and gentlemen. Up next is in-house legal team of the year, Airport, and the award in the notable category goes to Delhi International Airport Limited. The notable for in-house legal team of the year, Airport, is Delhi International Airport. Team Delhi International to make a quick move towards the stage. Our next award, in-house legal team of the year, Diversified Conglomerate, goes to notable is Vedanta Limited. Do we have Team Vedanta? In-house legal team of the year, Diversified Conglomerate, notable is Vedanta Limited. Our next award is in-house legal team of the year, Diversified Conglomerate. We have one more notable, Daimler India Commercials Vehicle. Daimler India Commercials Vehicle. Our next award is the legal startup of the year, the Global General Counsel. The Global General Counsel, the legal startup of the year. Up next is Techno Legal Service Provider of the Year, Complinity Technologies Private Limited. Complinity Technologies Private Limited, Techno Legal Service Provider of the Year. Up next is NGO NPO Social Enterprise of the Year goes to Apurva Foundation. Apurva Foundation. Our next award is in the category Academia, Law Academy of the Year goes to Law Prep. Law Prep. Law Prep, do we have representatives? Till that time I request School of Law, HITS to be ready to become near the stage. Law Academy of the Year goes to Law Prep. Law Prep. We need the representatives from the Law Prep. Law Prep. Law Institution of the Year goes to School of Law, Hindustan Institute of Technology and Science, HITS. The Academic Excellence Award, and the winner is Professor Dr. Anuradha Chadha, University School of Law, Desh Bhagat University, Mandi, Gobindgarh, Punjab. Please put your hands together, ladies and gentlemen. Up next is Academic Excellence Award Notable. It goes to Ms. Nikita Poradia Shah, Assistant Professor, Institute of Law, Nirma University. Ms. Nikita. Kindly keep the applause going. Up next is Legal Icon of the Year and goes to Mr. Manoj Kumar Singh, S&A Law Offices. Ladies and gentlemen, the Legal Icon of the Year. We need a louder round of applause. Up next is the Jury Special Honor for Lifetime Achievement, and the award goes to Mr. Lalit Bhasin. Mr. Bhasin, Dr. Bhasin started his law practice in 1962, has developed Bhasin & Company as one of the largest law firms in North India. Kindly keep this applause going. It's a special one, ladies and gentlemen. We request Dr. Bhasin to kindly give the acceptance speech. Sir, we request you to give the acceptance speech. We would love to hear from you, and many, many congratulations. A round of applause, ladies and gentlemen.
61 years in the legal profession. I have seen the evolution of this profession, and we are seeing and witnessing a great change in how the system of administration of justice is being brought to the doorsteps of the citizens under the present regime. And we are fortunate to have Shri Arjun Meghwalji, you see, as the law minister. He's brought in new vision for 2047, how India will be so far administration of justice is concerned. I'm grateful to SOCHAM for recognizing my small contribution in the field of law. Thank you.
And now, ladies and gentlemen, Jury Special Honor for Significant Contribution in the Legal Profession, and the award goes to Mr. Rajiv Malhotra, Ms. Gayatri Luthra, wife of Mr. Rajiv Luthra, will receive this prestigious award. A thunderous round of applause for Ms. Gayatri Luthra, receiving on behalf of Mr. Rajiv Luthra. Ma'am, would you like to give an acceptance speech? Ms. Luthra, would you like to give acceptance speech?
Well, I'm not one for speeches, but I want to say thank you to everybody. Rajiv was a wonderful, I promised myself I wouldn't get overwhelmed. He loved life, he loved people, he loved everybody. He trusted, he loved, and he lived a life king size. And I'm so grateful for having received this honor for him. Thank you. And today is our anniversary, and the first one after a special day indeed. Thank you.
And now, ladies and gentlemen, Women General Counsel of the Year in notable category goes to Shalini Kulshrestha. Thank you very much, dignitaries. With this, we come to an end of the National Legal Excellence Awards. And I now request Mr. Vijay Sachdeva, Co-Chairman, ASSOCHAM, National Council for Corporate Affairs, Company Law and Corporate Governance, and Group Head, Internal Audit in the Rama Corporation, to kindly propose a vote of thanks.
Good evening, ladies and gentlemen. Shri Arjun Ram Meghwalji, Honorable Minister for Law and Justice, my chairperson, Ms. Preeti Malhotra, our friends on the dais here, Mr. Akshat Khaitan, Mr. Rajendra Kumar, and of course, I am overwhelmed to hear from Shri Suresh Chandraji, who has contributed his 40 years into the law profession at a very important position in the ministry. So with this, let me at the outset mention that the jury which Ashocham has been highly recognized. It has all the luminaries, and as Ms. Preeti Malhotra mentioned that this is award which we are doing, followed with the CSR award, which has been a premium award in the country, which we started nearly 15 years ago. So as Meghwalji said, congratulations and compliments to all the winners today, and inspiration for all others, because inspiration is what is a bigger award for people to carry on for the future ambitions. With this, I will not take much time. Let me thank you once again, Meghwal Sahab, Ms. Preeti Malhotra, for ensuring that Meghwal Sahab is here with us today. It will be wonderful to hear Suresh Chandra ji. Maybe at the next occasion we will have his more time, because such experiences are really legendary for writing the roadmap for 2047, and that is what the compliments goes to Meghwal Sahab, because like corporates which have a larger mission, what Google will be 100 years down the line, or what Microsoft will be 100 years down the line. Similarly, countries have to have a larger vision, and this is the first time, so compliments to Meghwal Sahab and the current government, Modi Sahab, that we are trying to put up a roadmap for 2047, at the same time a roadmap for 2070 for climate change. So those are the long-term visions which are very important. With this, let me thank Mr. Sahab once again, Ms. Preeti Malhotra, all the members here. Let me especially thank Mr. Santosh Parashar from Ashocham team. Come, Santosh. You have Jatin, Vikas.
Yeah.
Come,
Yeah,
please.
Vikas. Yeah.
Vikas, Jatin. So,
15 months exercise.
Okay. So these are the real faces who have worked hard. Santosh, Jatin, come. From the Ashocham core team, and this has been a complete process over last 15 months. So the series of awards which we distributed over 15 minutes have been a very thorough process over last 15 months. So one round of applause for the entire team here. Thank you. So with this, we thank the sponsors, we thank the wonderful arrangements done by Imperial, and above all, thanks and a very wonderful good evening and a good weekend to all of you. Thank you.
We request the Ashocham team to please join us on the stage for a group photograph with the distinguished dignitaries present on the stage. We once again thank all the esteemed dignitaries for sparing their valuable time in joining us. We thank our esteemed audience for your participation and support. Thank you very much, and we request the gathering to please join us for high tea, organized outside the hall. Thank you very much and wish you a great evening ahead. Thank you.
मिलेगा वो बहुत अच्छा लगेगा।
तो उन्होंने बोला सेशन कराओ, कुछ सिखाओ, बट हम चाहते हैं आप हमारे कैंपस आओ और डेफिनेटली हम आपको वो चीज़ वहाँ पे सिखाएंगे। तो नेशनल कॉन्फ्रेंस है, टोटल ऑल ओवर अराउंड 700 पार्टिसिपेंट्स इसमें पार्टिसिपेट कर रहे हैं। तो वी रियली वांट कि अगर आपको ब्रोशर्स चाहिए, फोल्डर्स चाहिए, तो आप ज़रूर उसको लें और विद स्पाउस, विद चिल्ड्रन यू कैन कम एंड अटेंड द प्रोग्राम फॉर द लीगल प्रोफेशंस के लिए। ओम शांति।